Ever felt like you're navigating just this labyrinth of complex information, wishing someone could just distill the absolute essence, the most crucial insights, and hand them to you with clarity and maybe a bit of a spark?
Hmm.
Well, you've definitely come to the right place. Today, we're taking a deep dive into some foundational legal concepts. Things that, well, they often operate behind the scenes, but they profoundly shape the very bedrock of our justice system and public safety.
That's right.
We're talking about the legal mechanisms that compel evidence, track down illicit wealth, and proactively work to maintain peace and good behavior in society.
Exactly. Our mission today is to pull back the curtain on these intricate legal processes. How do we compel the production of items crucial for investigations? How do we navigate the really complex world of tracing and ultimately forfeiting the proceeds of crime? And also examine the critical framework for securing peace and good behavior within our communities. We aim to dissect these provisions, with a scholarly juristic approach, offering not just what the law says, but why it says it, how it's interpreted, and its real-world implications, turning what can seem like dense legal text into hopefully clear, actionable understanding for you.
Get ready for a truly insightful journey then. We're going to uncover the precise legal ingredients of these powers, explore their nuanced nature and scope, and then walk through some compelling scenarios that connect these concepts to real-world impact. We'll even touch upon the underlying legal theories and, maxims that govern these powerful instruments.
Sounds good.
Okay, let's kick things off with what I like to call the tools of investigation: compelling production and search. Now, at the heart of any effective investigation is the ability to get the necessary information, documents, or objects. The justice system seems to have this tiered approach, right? Starting less intrusive and escalating. Expert, when authorities need information or an item for investigation, what's often their first, most common legal step?
Well, the initial and often most straightforward tool in their arsenal is the summons to produce, which is detailed in Section 94. Think of it not as an accusation, but as a formal, legally binding request for information.
Okay.
The core ingredients are quite specific. It can be issued by a court through a summons or by an officer in charge of a police station via a written order. What's particularly modern and frankly fascinating is that this order can now be issued electronically.
Oh, that makes sense.
Yeah, it reflects the law's adaptability to our digital age.
Hmm.
This inclusion is really a recognition of the shift from purely physical documents to a landscape dominated by digital communication.
That makes total sense, especially with how much information lives online now.
Yeah.
So when we talk about what can be requested, are we just talking about old-fashioned paper files, like dusty ledgers?
Oh, far from it. The law specifies any document, electronic communication, including communication devices, which are likely to contain digital evidence or other physical thing.
Wow, okay.
It's a broad definition. It ensures that, no stone is left unturned.
Ah,
From traditional paper records to modern digital footprints like emails, messages, or data on a smartphone, the purpose is unequivocally to gather crucial evidence.
right.
This provision is used when production is deemed necessary or desirable for any investigation, inquiry, trial, or other proceeding under the Sanhita. The real insight here, I think, is that while it seems minor, Section 94's broad necessary or desirable clause makes it sort of the unsung hero of preliminary investigations. It lets authorities meticulously build a case, often behind the scenes, without the immediate public disruption or drama of a full-blown search warrant. It's the quiet workhorse of evidence gathering, reflecting that legal theory, lex plus est quam scientia law, is more than just knowledge. It's also about practical application.
So who exactly can be compelled to produce these items? Can it be anyone?
Indeed, the request can be made to any person in whose possession or power such document or thing is believed to be. This means it could be anyone from a private individual to the head of a major corporation, or even, say, a service provider holding digital records.
Okay.
The underlying object is simply to gather crucial evidence efficiently for legal proceedings. This is often the first step, a formal request for cooperation before more coercive measures, like a search warrant, are even considered. It implies a legal duty to assist, recognizing that justice depends on getting relevant information.
That sounds straightforward, but if I get such a request, do I always have to schlep down there in person, or can I just send the document?
Good question, and this is where pragmatism meets legal duty. Section 94, subsection 2, clarifies that a person required merely to produce a document or thing can comply simply by causing that item to be produced. You don't necessarily have to attend personally.
Oh, okay.
It respects people's time, reduces unnecessary burdens, but still secures the required evidence. The nature of this power is it's legally binding. Non-compliance can have serious repercussions, but it's deliberately designed to be less intrusive than a physical search. It strikes a balance.
Are there any limits to this power, though? Does it override other protections, like, say, client-attorney privilege?
Excellent and vital question. Yes, there are crucial limitations detailed in Section 94. It explicitly states that this section does not affect Sections 129 and 130 of the Bhartiya Nagrik Suraksha 2023 or the Banker's Books Evidence Act 1891.
Okay, so those specific protections remain.
Precisely. It means, for instance, established legal privileges, like legal professional privilege, where communications between a lawyer and client are protected, still apply. They can't be overridden by a summons to produce under this section.
Right.
Similarly, specific rules for bank records under the Banker's Books Evidence Act remain paramount. And, importantly, it specifically does not apply to items in the custody of postal authorities, things like letters, postcards, parcels.
Mail is different.
Mail is treated differently. It's considered highly sensitive and covered by a separate, more stringent provision. It acknowledges the enhanced privacy concerns around mail. This limitation really exemplifies a careful balancing act by the legislature, between the state's investigative needs and individual privacy rights. Certain sensitive areas get higher thresholds or specialized procedures.
So, to put this into a real-world context, imagine a major corporate fraud investigation. The investigator suspects an executive has been manipulating financial records, maybe communicating illicitly via email. Instead of immediately raiding the office, which could cause chaos, they can issue a summons. Right.
To a company's legal department, maybe the executor directly, requesting specific financial records, electronic devices, documents. The company could then compile and produce these, probably through their lawyers, without the exec needing to show up in court.
Exactly. It allows for efficient gathering while minimizing disruption.
And refusal. That would obviously escalate things.
Of course. Non-compliance carries its own legal consequences, potentially leading to those more coercive measures we mentioned.
Okay, and building on that, the distinct approach for items in postal custody you mentioned, that really highlights the law acknowledging unique sensitivities. Section 95 outlines these special rules for postal custody.
Precisely. Recognizing that items in the postal system carry a significant expectation of privacy.
So if investigators suspect a package or letter contains crucial evidence, they can't just send a standard Section 94 summons. What's the specific procedure then, given those privacy implications? Exactly. Section 95 sets up a two-tiered system. For direct delivery under Section 95, you need a higher level of authority, a district magistrate, chief judicial magistrate, a court of session, or even a high court.
Okay, the big guns.
Right. If one of these authorities deems an item wanted for an investigation, inquiry, or trial, they can directly require the postal authority to deliver that document, parcel, or thing to a specified person. That's a strong power, compelling the handover of private mail. It reflects that doctrine, salus populi suprema lex est, to the welfare of the people, is supreme but balanced with robust checks.
And what if it's a lower-ranking official who suspects something, maybe a local police chief? Do they have any recourse, or do they have to wait for the higher-ups?
That's where the detention for review provision of Section 95(2) comes in. Other magistrates, executive or judicial or police chiefs, like a commissioner or district superintendent, can require the postal authority to search for and detain such items.
So they can pause it.
They can pause it. But here's the crucial check. This detention is only pending a direct order from a higher magistrate or court under subsection 1. So a lower authority can temporarily freeze the item, prevent its delivery, but a higher judicial authority must ultimately authorize its full release for investigation. It's a carefully calibrated mechanism, a hallmark of due process.
It certainly aims for a clear balance, but I wonder, how often does that detention for review clause, even with its checks, become a point of contention? Is there a risk it still infringes on privacy, even temporarily, before the higher authority weighs in?
That's a perceptive point, and it really highlights the ongoing tension in legal practice. While the provision aims to balance needs, the temporary detention itself is an infringement, technically.
Right.
The judicial oversight before full delivery is what mitigates this, but the initial detention can still be challenged, maybe on grounds of insufficient reason to believe by the lower authority. It's a continuous area of legal interpretation, sometimes litigation. It reflects the dynamism of legal safeguards versus state power. The ultimate object is clear, though. Acknowledge the unique status and privacy implications of mail, balance the need for evidence against that expectation, and use a two-tiered approach for checks and balances.
Okay, so putting this into a real-world context, investigators suspect a drug consignment or maybe a ransom notice in the mail. A district magistrate, if they have enough grounds, could order the post office to intercept and deliver that specific package.
Right.
Alternatively, a local police superintendent gets credible intel about a suspicious package. They could order the post office to detain it, hold on to it, while they quickly get a formal order from a chief judicial magistrate for its full delivery and examination.
Exactly. That ensures judicial oversight, even in urgent situations, while respecting privacy.
So the summons is about formal requests. But what happens when those requests are just ignored? Or worse, when authorities suspect evidence is actively being hidden or destroyed, when does the law allow for, well, a more forceful hand?
That's precisely when we escalate to search warrants, which are detailed in Section 96. These represent a more direct and, frankly, often more intrusive intervention. A court may issue a search warrant under three primary circumstances, effectively bypassing the less coercive summons.
What are those key triggers then? What justifies such a powerful instrument?
The first trigger, under Section 96, 1A, is if the court has reason to believe that a person who has been issued or might be issued a summons under Section 94 or a requisition under Section 95(1) will not or would not produce the required document or thing.
So anticipated noncompliance.
Exactly. Anticipated noncompliance, perhaps due to obstruction, a history of non-cooperation, or a perceived risk of evidence destruction. The court isn't waiting for a refusal, it's anticipating it based on credible information.
Okay, so if they think someone's going to hide something, they go straight for the warrant. What about situations where they don't even know who has the evidence?
That's the second trigger, Section 96, 1B, which is quite practical. If such document or thing is not known to the court to be in the possession of any person.
Oh, okay.
This addresses situations where the evidence exists, but its precise location or custodian is unknown. Makes a targeted summons impossible. For example, if evidence is thought to be in a public place or a large property with multiple occupants, no clear custodian.
And the third trigger seems even broader, allowing for a, quote, general search.
Indeed. The third, Section 96(1)(c), is for more expansive situations. If the court considers that the purposes of any inquiry, trial, or other proceeding will be served by a general search or inspection. This is a broader power, allowing for a wider sweep when the scope of evidence isn't yet tightly defined, but a search is deemed essential. The nature of a search warrant, compared to a summons, is that it's far more forceful, more intrusive. It's used when those less coercive methods are deemed insufficient or impractical. It kind of embodies that legal principle, necessitas non habet legem necessity, knows no law, but always within the bounds of a judicial order. The object is to compel production or discover evidence directly.
That's a significant power. But does a search warrant give the police free rein? Can they just search anywhere and everywhere? What about limits on its scope?
This is a crucial area for protecting individual rights. Section 96(2) provides for limits on scope and specificity. The court has the discretion to specify in the warrant the particular place or part thereof to which only the search or inspection shall extend.
Okay, so it has to be targeted.
It should be targeted.
Yeah.
The executing officer must adhere strictly to these specified boundaries. It prevents fishing expeditions and ensures searches are proportionate. This specificity is a vital safeguard against arbitrary intrusion, a cornerstone of due process in searches.
What about those sensitive postal items we just discussed? Can any magistrate issue a search warrant for mail?
No, absolutely not. Section 96(3) imposes a strict limitation here. Nothing contained in this section shall authorize any magistrate other than a district magistrate or chief judicial magistrate to grant a warrant to search for a document, parcel, or other thing in the custody of the postal authority.
So again, a higher bar for mail.
Exactly. It reinforces that special protection, requiring a higher level of judicial authority for such intrusive searches, maintains consistency and enhanced scrutiny for sensitive areas like mail.
Okay, illustrating this. Let's say a court suspects a key witness in a murder trial is actively destroying evidence on their computer, despite getting a summons. The court, believing noncompliance is imminent, could issue a search warrant for the witness's home, specifically authorizing seizure of electronic devices.
Yes, a targeted search based on anticipated noncompliance.
Or, in an illegal arms ring case, police have intel that weapons are hidden somewhere in a huge warehouse, but they don't know the exact spot. A court could issue a warrant for a general search or inspection of the whole warehouse.
Correct. In both cases, the warrant bypasses the limitations of just a summons, allowing direct, forceful action when necessary.
Okay. Beyond these general search warrants, the law also provides for specialized ones, right? Specifically for targeting illicit goods.
Yes, precisely. That falls under Section 97, search of places for stolen property, forged documents, etc. This provision is a powerful tool specifically designed to disrupt organized crime and prevent economic harm.
So this isn't just about gathering evidence. It's about actively seizing and removing illegal items from circulation. Who gets to issue these specialized warrants?
These can be issued by a district magistrate, subdivisional magistrate, or a magistrate of the first class. The trigger is quite specific, requiring judicial discretion. The magistrate must have reason to believe, based on information and after such inquiry as he thinks necessary, that a place is used for depositing or selling stolen property or for depositing, selling, or producing objectionable articles.
Okay, reason to believe after inquiry. That sounds like a key check.
It is. It ensures judicial oversight and prevents arbitrary raids. It's a core principle. It also applies if such objectionable articles are simply deposited somewhere.
When such a warrant is issued, what exactly can the police do? It sounds like they have broader powers than just a general search warrant allows.
They do. The warrant authorizes any police officer above the rank of constable to take several decisive actions. First, they can enter, with such assistance as may be required, such place. Second, to search the same in the manner specified in the warrant, again, emphasizing defined scope.
Right.
Third, and crucially, take possession of any property or article therein found which he reasonably suspects to be stolen property or objectionable article. That reasonable suspicion standard gives the officer immediate discretion on the scene. Fourth, they can convey such property or article before a magistrate, or guard it on the spot, or secure it elsewhere. And fifth, significantly, they can take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, sale, or production, knowing or having reasonable cause to suspect it to be stolen property or objectionable article.
Wow, so they can make immediate arrests of people involved right there.
Yes, it allows for immediate arrest of those actively involved, facilitating the disruption of the illicit operation.
That's quite comprehensive. It targets the people and the goods. Now that term, objectionable articles, it sounds specific. What exactly does the law include in that definition?
It is defined with remarkable precision in Section 97(2). Provides clear legal boundaries, no vague catch-alls. It's a specific list. A, counterfeit coin. B, certain pieces of metal made illegally or imported illegally. C, counterfeit currency note, counterfeit stamps. D, forged documents. E, false seals. F, obscene objects as defined in the BNS. And critically, G, instruments or materials used for the production of any of the articles mentioned in clauses A to F.
Ah, so not just the fake notes, but the printing press too.
Exactly. That last point is particularly insightful. It targets not just the illicit product, but the entire infrastructure that creates it. It aims to dismantle the operation and prevent future offenses.
What's truly insightful about Section 97 is that proactive, almost surgical approach. It doesn't just punish the sale, but actively aims to dismantle the entire production chain by targeting the instruments or materials. That shifts law enforcement from reactive to truly preventative, hitting organized crime's infrastructure.
Precisely. The fundamental purpose of Section 97 is to disrupt organized crime, prevent economic harm, uphold public morality by targeting these specific illegal items and activities. It operates on the theory that crime shouldn't profit and goods created illegally are subject to seizure. It's proactive.
Okay, practical example. Intelligence suggests an illegal printing press is running in an industrial unit making fake currency. A magistrate, based on this, issues a Section 97 warrant.
Right.
Police raid the place. They seize not just the fake notes, but also the printing machines, the special paper, the ink, all instruments or materials, and anyone found operating the press looking like they knew what was going on gets arrested on the spot.
Exactly. A comprehensive shutdown and immediate accountability. That's the power of Section 97.
Now, our justice system also deals with challenges beyond tangible objects, right? Extending into ideas and publications. Section 98, power to declare publications forfeited, allows the state to intervene against material deemed harmful, but, crucially, with significant judicial safeguards.
Absolutely. This is a delicate area, balancing public order with the fundamental right to freedom of expression.
So what exactly triggers this power, and what kind of content are we talking about here? It sounds like a slippery slope.
You're right. It's a very sensitive balance. The trigger is when the state government believes any newspaper or book or any document wherever printed contains matter whose publication is punishable under specific sections of the Bhartiya Nagrik Sanhita.
Okay, specific criminal offenses related to publication.
Yes. Typically related to grave offenses against public order, incitement, or obscenity. Things like Section 152, promoting enmity, 196, public mischief statements, 294, obscene books, 295, outraging religious feelings, or 299, obscenity. The decision isn't arbitrary. It's tied to criminal acts of publication, highlighting the difference between merely offensive speech and illegal incitement.
And what's the formal process once that belief is formed by the state government?
The state government initiates it by issuing a formal notification in the official gazette. This notification must explicitly state the grounds for its opinion. That's key for transparency and potential challenge, and then declare every copy of that publication forfeited to the government.
Okay.
Once declared, any police officer can seize copies wherever found. Plus, a magistrate can issue a search warrant specifically to a sub-inspector or higher to search premises where copies are suspected to be hidden. It reflects that legal theory, res paret domino, loss falls on the owner, as the illegal content taints the publication itself.
Just to be clear, what exactly counts as a newspaper, book, or document here?
Section 98(2) defines them. Newspaper and book use the definitions from the Press and Registration of Books Act, grounding them in existing law. Document is broad. Any painting, drawing, or photograph or other visible representation covers a wide range of media.
Right.
The purpose of Section 98 is to allow the state to intervene against publications deemed harmful, especially those inciting disorder or violating morality. But as you said, the next section, Section 99, provides that crucial judicial safeguard against potential overreach or censorship. It emphasizes the importance of freedom of speech.
Wow. Challenging a state-mandated forfeiture directly in the high court, that feels like a monumental safeguard for free speech. Expert, what kind of precedent does this set? How independent is this special bench in practice when pushing back against government action?
This is where the legal system truly shows its commitment to checks and balances. It's critical for upholding constitutional liberties. Section 99 is specifically designed as a robust judicial safeguard. Any person having any interest in the forfeited publication, author, publisher, printer, even a distributor, has the right to apply to the High Court to set aside that declaration of forfeiture.
And there's a time limit.
Yes, within 2 months from the date the forfeiture notification was published. A clear window for challenge. The very existence of this right is a testament to the constitutional protection of free speech, embodying that maxim ubi jus ibi remedium, where there is a right, there is a remedy.
So it goes straight to the high court. Is there a special procedure for hearing these cases?
Yes, absolutely. Such applications are heard and determined by a special bench of the High Court. If the High Court has 3 or more judges, the bench has 3 judges. If fewer than 3, the bench comprises all the judges.
Okay, so it's not just one judge making the call.
Exactly. It mandates a high level of judicial scrutiny, collective wisdom, ensures decisions impacting such fundamental rights are carefully considered, often leading to more robust judgments.
What kind of evidence can they look at in court? Can the court just read the publication itself?
Section 99 clarifies this. For a newspaper challenge, any copy of such newspaper may be given in evidence in aid of the proof of the nature or tendency of the words, signs, or visible representations. This lets the High Court directly assess the content that led to the forfeiture in its full context, not just relying on the government's summary. Crucial for fair assessment.
So what's the High Court's ultimate role then? Can they just rubber stamp the government's decision? Or do they really scrutinize it?
They must scrutinize it. Section 99 is very clear. The High Court shall, if it is not satisfied that the publication contained any such matter as is referred to in Section 98, set aside the declaration of forfeiture.
Shall set aside. That's strong language.
It is. It places the burden effectively on the state to satisfy the High Court that the publication indeed contained the punishable matter. If the judges disagree, the majority opinion prevails. This framework reflects that delicate balance between societal protection, salus populi, and freedom of expression. The judiciary acts as the ultimate guardian here against potential executive overreach.
Okay, so illustration. A book is published. State government believes it has highly inflammatory stuff meant to incite communal violence, punishable under BNSS Section 152. They issue a forfeiture notification.
Right.
But the publisher argues, no, this is artistic expression, political commentary within free speech limits. They challenge it in the High Court.
Okay.
A special bench reviews the book, hears both sides, and critically decides if it actually contains matter punishable under the law. If they're not satisfied with the state's case, they must set aside the forfeiture, protecting the publisher's right.
Precisely. That's the safeguard in action.
Moving from abstract publications to the very real, immediate protection of individuals, the law also provides direct tools for rescuing people from unlawful confinement. Section 100 details the search for persons wrongfully confined.
Yes. This addresses a deeply serious situation, a fundamental violation of liberty.
What kind of information or belief triggers such a search? It must be serious.
If a district magistrate, subdivisional magistrate, or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offense, they can issue a search warrant.
Reason to believe. That's the key phrase again.
It is. It implies a rational connection to credible information suggesting an offense, kidnapping, unlawful detention, human trafficking has occurred. It's not speculative, it's grounded in factual apprehension. Reflects the state's role as parents, patria parent of the country to protect citizens.
And once the warrant is issued, what's the immediate goal?
The person directed by the warrant, usually police, is authorized to search for the confined person, following the warrant's terms. If the person is found, they are immediately taken before a magistrate, who then shall make such order as seems proper. The object is swift location and freeing of individuals illegally deprived of liberty. Speed is paramount here.
And there's a related, maybe even more forceful, provision for specific vulnerable individuals, particularly women and children.
Yes, Section 101 addresses the power to compel restoration of abducted females. This comes into play upon complaint made on oath of the abduction or unlawful detention of a woman or a female child for any unlawful purpose.
Unlawful purpose is key there.
Very key. Often implies exploitation, forced marriage, trafficking.
What's the authority here and how robust is their power to act?
Again, a district magistrate, subdivisional magistrate, or magistrate of the first class, they can make an order for the immediate restoration of the woman to liberty or the child to her lawful guardian. Crucially, the magistrate may compel compliance with such order, using such force as may be necessary.
Using necessary force, that's strong.
It is robust. It acknowledges the heightened vulnerability in these cases. The object is rapid return to safety and legal custody, addressing grave exploitation. Embodies that maxim fiat justitia ruat caelum, let justice be done, though the heavens fall, emphasizing the rescue.
So a concrete illustration for Section 100, family files a missing person report. Intel suggests they're held captive in a specific farmhouse, maybe kidnapped. Magistrate issues a search warrant. Police enter, search, find the person, bring them immediately to the magistrate.
Correct. Swift rescue.
And for Section 101, a complaint on oath states a minor girl was abducted for forced labor. Magistrate verifies, orders immediate restoration to her guardian, authorizing police to use necessary force for her safe return.
Exactly. Quick intervention when vulnerability is highest.
Okay. All these search procedures, general warrants, specialized ones, even rescues, they operate under a set of general rules for searches, right? To ensure due process and accountability. Section 103 seems key here.
Absolutely. These rules are critical for protecting individual rights during state action. It's not just about getting the warrant, it's about how the search is done.
So even with a warrant, there are strict rules, not just a free-for-all.
Definitely not. The law is meticulous. Section 102 first clarifies that general procedural sections from other parts of the Sanhita-like execution of warrants dealing with resistance apply consistently across these different search warrants. Ensures uniformity.
Okay. And for a closed place, like a home or locked office, what are the rules of entry?
Section 103 mandates fundamental safeguards. The person in charge must allow free ingress upon demand and production of the warrant. They must also afford all reasonable facilities. It's a legal obligation.
Then if they refuse entry?
If ingress is refused, Section 103.2 allows the officer to proceed like they would for executing an arrest warrant in a closed place referencing Section 442. This implies breaking in if necessary, but only after proper procedure and if authorized. A crucial balance. Authority versus arbitrary forced entry.
What about searching people present during the search? That sounds like a potential area for abuse.
Under Section 103, people in or about the place reasonably suspected of hiding articles can be searched. But here's a critical, gender-sensitive safeguard. If such person is a woman, the search shall be made by another woman with strict regard to decency.
That's vital.
Absolutely. For upholding dignity, preventing harassment, ensuring respect, and cultural sensitivity.
One of the most talked about aspects is witnesses. How is that handled to ensure transparency? Like, independent observers.
This is fundamental for transparency and accountability. Section 103(4) mandates that before making a search, the officer shall call upon 2 or more independent and respectable inhabitants of the locality to attend and witness. They can even be compelled by written order. If locals aren't available or willing, people from another locality can be called.
That's a huge check on power.
It is. Designed to prevent false accusations or planted evidence, reflects that maxim. Justice must not only be done, but must also be seen to be done.
And what's the exact protocol with these witnesses? Do they just stand there?
Section 103(5) specifies the search shall be made in their presence. A detailed list of all seized items and their locations must be prepared by the officer and signed by these witnesses. Crucial documentation. Witnesses aren't generally forced to attend court later unless specifically summoned, protecting them from undue burden while recording their attestations.
What rights does the occupant of the place being searched have? Can they watch? Get a copy of the list?
Absolutely. The occupant or their representative must be permitted to attend during the entire search, per Section 103(6). And they must receive a signed copy of the list of seized items. Ensures transparency, allows verification.
Okay.
If a personal search happened under subsection 3, Section 103(7) requires a separate list of items taken, copy delivered to the searched person. And showing the seriousness, Section 103 states refusing to witness without reasonable cause, when ordered, is an offense itself under the BNSS, underscores the civic duty involved.
It's clear these rules are about fairness, preventing abuse. Is there ever direct judicial oversight during a search beyond just issuing the warrant beforehand?
Yes, Section 108 allows for that. Any magistrate competent to issue a search warrant may direct a search to be made in his presence. Direct judicial oversight, ensuring immediate legality. Powerful, though maybe rarely invoked. Furthermore, Section 109 grants any court the power to impound, take into its custody, any document or thing produced before it, maintaining direct judicial control over evidence. The combined object and legal theory here are transparency, accountability, protecting rights against arbitrary state power, due process and action, ensuring searches are fair, witnessed, documented, and reviewable. It's an application of omnium alterum partem, ensuring all sides, including the public via witnesses, can observe and verify.
In a world driven by tech, its vital legal processes keep pace. The law seems to have made strides in modernizing evidence collection, especially with digital recording and cross-border reach. Expert, what's the most significant recent update to how searches are recorded?
Indeed, this is a critical evolution. Section 105 introduces a potential game changer, audio-video electronic recording of search and seizure. This section mandates that the process of conducting a search, including preparation of the list of all things seized and signing by witnesses, shall be recorded through any audio-video electronic means, preferably mobile phone.
Wow, shall be recorded. That's huge for transparency.
It is a huge step. The police officer must also, without delay, forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate of the first class. The object is profound. Ensure transparency, prevent disputes over seizures, provide irrefutable evidence of procedures, enhances accountability and justice significantly, directly addresses historical concerns about planted evidence or irregularities. It adapts that principled justice must be seen to be done using modern technology.
That's a profound shift. Seems like it would drastically reduce disputes over what was found or how a search went down. What about immediate seizure of property by police? Say they just stumble upon something suspicious outside of a formal warrant.
That's covered by Section 106. Power of police officer to seize certain property. Any police officer can seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense.
So, immediate power.
Yes,
Yep.
immediate power to secure potentially criminal property, prevent its disposal or loss. If the seizing officer is subordinate, they report up. Critically, every officer acting under this power must forthwith report the seizure to the magistrate having jurisdiction. Ensures accountability for these immediate actions.
So police can seize property on suspicion. That's a powerful, immediate tool. I'm picturing a movie scene, detective finds a bag of hot cash in a car. But expert, in the real world, what's the most maybe unusual or surprising item you've seen seized under this power? Or a situation where this immediate action really turned the tide?
It's often the seemingly innocuous items that yield the most. Cash is common, yes, but I recall a case. Police officer investigating a petty theft noticed an old, distinctly patterned blanket in a suspect's car. Didn't seem connected directly, but the pattern was so specific it raised suspicion. He seized it under this very section. Turns out it was a unique blanket described by the victim of a much larger, unrelated burglary. Provided a critical, immediate link to a serious crime, led to breakthroughs. It's those moments of intuitive judgment, backed by this legal power, that can pivot an investigation.
How do they handle custody of seized property, especially if it's bulky or, say, perishable?
The law is wonderfully pragmatic here. If property can't be conveniently transported or stored, or if continued police custody isn't needed for investigation, custody can be given to someone on their executing a bond to produce it later in court.
Okay, practical.
And for perishable goods of low value, under 500, if the owner is unknown or absent, they may forthwith be sold by auction under the orders of the superintendent of police. Balances preserving value with practicality, avoids waste. The object is immediate power to secure property, but with responsible handling procedures.
With crime becoming increasingly global, how does the legal system handle evidence or warrants that cross state lines or even national borders? That seems like a massive hurdle.
That's precisely where Section 110, Reciprocal Arrangements for Processes, comes in. Enables law enforcement and judicial systems to operate effectively across geographical and national boundaries. It outlines two key areas. First, interstate cooperation within India. Summons or warrants can be sent by post or otherwise to a court in another state or area for service or execution.
So one state court helping another.
Exactly, effectively requesting judicial assistance.
And internationally. For truly transnational crimes, how does that work?
For international cooperation, summons or warrants can be sent to contracting states' countries with reciprocal arrangements. These processes are transmitted, usually in duplicate in a specified form, to a designated foreign court, judge, or magistrate via specified authority. Reflects the principle of comity of nations, where states mutually respect and enforce each other's laws.
Right.
It recognizes crime doesn't stop at borders, and neither should justice.
And what if India receives such a request from abroad, a foreign court needing help getting evidence here?
Section 110(2) ensures reciprocity. Indian courts receive and execute summons or warrants from other Indian states or from contracting states as if they were local. If a foreign arrest warrant is executed, the person is dealt with following procedures similar to our Sections 82 and 83. If a foreign search warrant is executed, items found are dealt with per Section 104, then forwarded to the issuing foreign court.
Okay.
The overarching object is facilitating justice in an interconnected world. Ensuring criminal processes aren't halted by borders, it's the spirit of universal jurisdiction made practical.
That's incredibly important for tackling transnational crime. Now, let's pivot to a related but distinct area that's become increasingly critical. Following the money. Tracing and forfeiting proceeds of crime. This chapter deals with illicit gains, and like any complex legal area, it all starts with clear, precise definitions.
Absolutely. Section 111, Essential Definitions, provides the critical legal lexicon. Without these precise definitions, it would be impossible to legally combat financial crimes, especially cross-border ones. This is the conceptual framework for effective asset recovery, reflecting the sophistication of modern financial crime.
What are the key terms we need to unpack here to understand how authorities go after ill-gotten gains?
First, a contracting state, defined as any country or place outside India with which the central government has arrangements, typically a treaty, for criminal matters, the basis for international cooperation in financial crime.
Okay. Then there's identifying. What exactly does that mean here?
Identifying means establishing a proof that the property was derived from or used in the commission of an offense. This is the foundational evidentiary step, proving the direct legal link between the asset and the crime. Not enough to suspect. Legal proof must be established, often painstaking work.
And the central concept, proceeds of crime, that seems very broad. How's it defined?
Proceeds of crime is indeed broadly defined. Any property derived or obtained directly or indirectly by any person as a result of criminal activity, including crime involving currency transfers, or the value of any such property.
Or the value.
Yes, includes not just the assets themselves, but their monetary equivalent. Ensures criminals can't just convert gains to avoid forfeiture. The inclusion of currency transfers highlights its modern applicability to fluid financial flows, whether traditional banking or digital currencies.
Property itself can be vague, expert. How is it legally constrained here for comprehensive coverage?
Property gets a very expansive definition. Covers assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and deeds and instruments evidencing title to or interest in such property or assets derived or used in the commission of an offense. Crucially, it explicitly includes property obtained through proceeds of crime.
So pretty much anything linked to the crime.
Exactly. Any asset, regardless of form, building, intellectual property, share certificate, if linked, can be targeted. This broad scope reflects that theory crime should not be profitable. Nullus commodum capere potestas sua injuria propria. No one profits from their own wrong.
And finally, tracing. This sounds like the detective work part of it all.
Exactly. Tracing means determining the nature, source, disposition, movement, title, or ownership of property. The forensic investigative process, following the money trail, identifying how illicit funds moved, where they were laundered, where they ultimately landed.
Yeah.
These precise definitions collectively provide the indispensable legal language for combating sophisticated financial crimes. Their purpose: equip the state with unambiguous tools to pursue and reclaim assets derived from illegal activities, laying the groundwork for asset recovery. This whole chapter rests on the premise that the state can reclaim these assets, stripping criminals of incentive.
With those precise definitions clear, let's look at how these mechanisms work domestically to reclaim illicit wealth. Section 107 covers attachment, forfeiture, or restoration of property, a crucial domestic tool.
Right. This domestic process starts with initiation under Section 107. Inical. A police officer, if they have reason to believe property is derived from criminal activity, can, with essential approval from a superintendent or commissioner of police, apply to the court or magistrate having jurisdiction.
That approval seems important. A check.
Yes, a supervisory check before the often intrusive asset attachment process begins. Adds accountability.
So if the court agrees there's good reason, what's next? Does the person immediately lose their property?
Not at all. A crucial safeguard is the show cause notice under 107(2) and 3. If the court or magistrate believes the properties are crime proceeds, they issue a notice, giving the person 14 days to explain why an order of attachment shall not be made.
14 days to respond.
Yes, and if the notice specifies property held by someone else on behalf of the accused, that person also gets a copy. Ensures all interested parties are informed. Embodies alterum partem, fair opportunity to present their case, show legitimate origin.
And after getting their explanation, what's the court's role in deciding?
Under 107(4), the court magistrate meticulously considers the explanation, available material, gives a reasonable opportunity of being heard, in person or via lawyer. Then they can pass an attachment order for properties found to be proceeds of crime.
What if they just don't show up or respond?
Significant proviso. If the person doesn't appear or represent their case within 14 days, the court may proceed to pass the ex parte order, an order without hearing their side. Ensures dilatory tactics don't halt justice.
What if there's a risk that just issuing the notice gives the criminal time to hide or move the assets before the process can even start?
Section 107(5) addresses that exact concern with an interim attachment provision. If the court magistrate believes issuing notice would defeat the object, like if assets are liquid, easily transferable, they can pass an ex parte interim attachment or seizure order.
Ah, quick freeze.
Exactly, a quick freeze. This order stays in force until a final order is made, allows swift action to prevent dissipation, reflects that live pendens principle. Property subject to litigation shouldn't be freely transferred to defeat the outcome.
Once it's confirmed as proceeds of crime, what happens to the money or property? Does the government just keep it?
Not always.
Yeah.
Sections 107(6) and 7 outline a very important aspect: distribution to victims. If properties are found to be proceeds of crime, the court, quote, shall by order direct the district magistrate to ratably distribute such proceeds to the persons who are affected by such crime within 60 days.
Distribution of victims first, that's crucial.
It is. Aims for restitutio in integrum, restoration, for victims, not just punishment. Provides tangible benefit to those harmed.
And if there are no victims, or maybe a surplus after compensating them.
Under 107(8), if no claimants, or none ascertainable, or if there's a surplus, such proceeds of crime shall stand forfeited to the government. The nature and object are clear. Divest criminals of illegal wealth. Provide restitution where possible. Ultimately, disrupt the economic incentives for crime. Ensure crime doesn't pay. The systematic process ensures due process even while targeting illicit gains.
Okay, Now, to truly combat modern crime, especially financial crime, international cooperation seems essential. Criminals don't respect borders, so the law needs to cross them too. That's covered in several key sections, right? A web of mutual legal assistance.
Precisely. It's indispensable.
So, if evidence for a crime investigated in India is abroad, maybe a Swiss bank account, a server somewhere else, how do our authorities legally get access?
That's where letters of request for investigation abroad under Section 112 come in. If an investigator believes evidence is in a contracting state, a country with reciprocal arrangements, an Indian criminal court can issue a letter of request to a foreign authority.
Asking them for help.
Yes, asking them to examine persons, record statements, get documents, things, and forward all that evidence or authenticated copies back to the Indian court. Transmission method is specified by the central government. Crucially, evidence collected this way is deemed to be collected during the course of investigation under this Sanhita, ensuring admissibility here.
Right.
The object is overcoming jurisdictional barriers for complex cross-border crimes. Embodies judicial comity.
What about the reverse? A foreign court needs help getting evidence from India.
Section 113 provides for letters of request from abroad. When the central government receives such a letter, it can, if it thinks fit, forward it to a chief judicial magistrate, or judicial magistrate here. That magistrate summons the person, records statement, gets the item produced, or the central government can send the letter to a police officer for investigation, treating the offense as if committed here. Collected evidence goes back to the central government for transmission abroad. Establishes a robust reciprocal framework, global cooperation against transnational crime, clear application of comity.
International cooperation isn't just about evidence, but also securing people, right? Arresting suspects, bringing witnesses from other countries.
Absolutely. Section 114 details assistance in securing transfer of persons. Indian courts can send warrants for arrest or to produce things to contracting states for execution under specified conditions. We can also request attendance of a person from a contracting state for investigations here.
And we honor their requests too.
Reciprocity is key. Indian courts execute warrants received from contracting states as if they were domestic. There are also detailed provisions for prisoner transfers in 114.4 and 5, ensuring conditions imposed by either country are respected when prisoners move for investigation or trial. Ensures crucial individuals can be secured, facilitating international justice, preventing fugitives escaping accountability.
And bringing it back to proceeds of crime, how does this cooperation extend to tracing and forfeiting assets hidden across borders?
That's Section 115, assistance in relation to orders of attachment or forfeiture of property. If an Indian court orders attachment forfeiture and suspect's property is in a contracting state, the court issues a letter of request to the foreign authority to execute that order there.
Okay.
Conversely, if the central government gets a request from a contracting state for attachment forfeiture of crime proceeds located in India, or an offense there, it forwards the request to an Indian court for execution under our relevant laws, including sections 116 to 122, the detailed forfeiture process.
So it's about making sure criminals can't just move their ill-gotten gains abroad and put them beyond reach?
Precisely. The object is preventing criminals escaping forfeiture by moving assets internationally, ensuring effective global asset recovery. Section 123 emphasizes using specified forms and manners for all these communications, ensuring clarity. And Section 124 allows tailored arrangements with specific contracting states, providing flexibility. Reflects mutual legal assistance, a cornerstone of international criminal justice cooperation. Necessary sophistication for transnational organized crime.
Now that we've grasped the crucial international aspect, let's dive deeper into the nuts and bolts of the detailed forfeiture process, from tracing to confiscation within India. The systematic legal journey to reclaim illicit gains.
Indeed. It starts with identifying unlawfully acquired property under Section 116. When a court gets information or an international request, it shall direct any police officer not below, sub-inspector, to take all steps necessary for tracing and identifying such property. A proactive, legally sanctioned investigation begins.
What kind of steps? How extensive can this tracing inquiry be?
The scope is explicitly broad under 116.2. Steps may include any inquiry, investigation, or survey in respect of any person, place, property, assets, documents, books of account, in any bank or public financial institutions or any other relevant matters.
So very wide net.
Yes. Ensures no aspect of financial life or assets is beyond scrutiny if relevant. The officer follows directions issued by the court. The object, systematically uncover and legally establish the precise link between assets and crime, build an irrefutable case for forfeiture.
Once they've identified suspect property, what's the next step to stop it vanishing before the full legal process unfolds?
That leads to interim seizure or attachment of property under Section 117. An officer doing the tracing, if they have reason to believe property is likely to be concealed, transferred, or dealt with to dispose of it, can order its seizure. If seizure is impractical, they order attachment prohibiting transfer without permission. A copy must be served on the person concerned.
So the officer can just seize it then and there. Is there any judicial oversight on that immediate power?
Crucially, yes. This interim order shall have no effect unless the said order is confirmed by an order of the said court within a period of 30 days of its being made.
Ah, court confirmation within 30 days?
Yes, a vital safeguard against arbitrary seizures ensures assets are only frozen temporarily until a court reviews the basis. The object is freezing assets quickly to prevent dissipation while the formal process gets underway. Reflects that liscel pendens principle again.
Once property is seized or forfeited, who looks after it? Who manages these assets? Could be a building, could be complex finances.
That's the role of management of seized or forfeited properties under Section 118. The court can appoint the district magistrate of the area or their nominee as an administrator. This administrator shall receive and manage the property following central government rules and conditions. They also take such measures to dispose of the property which is forfeited. The object is proper care, valuation, and eventual disposition. Prevent deterioration, misuse, loss of value while in state custody.
After all this intensive investigation and interim measures, when does the final formal decision on forfeiture happen? What's the individual's last chance to make their case?
The formal process culminates with the notice of forfeiture of property under Section 119. If, after inquiry and interim actions, the court has reason to believe properties are indeed proceeds of crime, it serves a notice on the person affected and anyone holding property for them.
Another notice period.
Yes, a period of 30 days
Yeah.
to indicate the source of income, earnings, or assets used to acquire the property, evidence they rely on, and show cause why. Such property should not be declared proceeds of crime and forfeited. This show cause process is fundamental due process. Fair, final opportunity to prove legitimate origin, counter the state's claims, natural justice.
And then the ultimate decision, the final forfeiture order. What's the impact of that finding?
After considering the explanation, all material providing a reasonable opportunity of being heard, the court shall record a finding whether all or any of the properties are proceeds of crime. Ex parte finding possible if they don't appear. Section 122 handles mixed property. If some is clearly crime proceeds but not all identifiable, the court specifies properties to the best of its judgment.
Okay.
The moment the court finds property as proceeds of crime, Section 123 states, such property shall stand forfeited to the central government free from all encumbrances.
Free from all encumbrances. That's powerful.
It is cleared of any claims or charges. If it includes shares, Section 124 says the company shall forthwith register the central government as the transferee, overrided other laws like the Companies Act, ensures the ultimate aim, legally transferring illicit gains to the state. The theory, nemo that quod non habet, can't give what you don't have, applies. The criminal never had legitimate title.
Is there ever an alternative to full forfeiture? What if only part of the property is proven tainted?
Section 121 offers nuance. Fine in lieu of forfeiture. If the court declares forfeiture but finds the source of only a part has not been proved legitimate, it can offer the person affected an option. Pay a fine equal to the market value of such part instead of forfeiture.
Ah, pay the value of the tainted part.
Yes. A hearing is required. If the fine is paid, the court may revoke the declaration of forfeiture and the property is released. Provides flexibility, proportionality, financial penalty for partially tainted assets, not always all or nothing, more equitable sometimes.
What if criminals try to quickly transfer assets once they realize proceedings are starting, trying to make them disappear before the order?
The law anticipates this, Section 122, declaring transfers null and void, a powerful anti-evasion measure. It states any transfer of property that occurs after an order under Section 117(1), interim attachment, or the issue of a notice under Section 119, forfeiture notice, is issued, will be ignored for the purposes of these proceedings. Yes. If such property is later forfeited under Section 120, then the transfer or shall be deemed to be null and void. The object, prevent circumvention via sham or quick transfers once proceedings begin, reinforces lis impedens. The theory, such transfers intend to defraud the legal process, lack legal validity, a legal nullity.
This detailed process truly shows a commitment to stripping criminals of ill-gotten gains. Now, let's shift gears completely. Maintaining public order, security for peace, and good behavior. This is about preventive justice, ensuring stability, safety. Expert, this seems like a very different side of the legal coin, proactive, not reactive.
Indeed. This chapter introduces a fascinating aspect, preventive justice. Unlike punitive justice, which punishes after a crime, these provisions aim to prevent potential disturbances and offenses before they occur. Often involves requiring bonds for future good conduct. A deterrent, a mechanism for community safety. Applies the principle prudentia est mater virtutum prudens is the mother of virtues to state governance.
Let's start with security for keeping peace on conviction, Section 125. When does this come into play?
This is preventative, but after a criminal conviction. When a court of session or magistrate of the first class convicts someone of certain specified offenses, like those under BNS Chapter 11, with exceptions, assault, mischief, criminal intimidation, or anything likely to breach peace, and deems it necessary to take security for keeping the peace, the court can, at sentencing, order them to execute a bond or bail bond for keeping peace.
How long can that bond last? And what if the conviction is overturned on appeal?
Period can be not exceeding 3 years. If conviction is set aside on appeal, the bond immediately becomes void, shows its direct link to the conviction. Appellate or revisional courts can also issue these orders. The object deter future breaches by those who've shown propensity through conviction, using past conduct as a predictor.
So that's after conviction. What about preventing disturbance before any crime is actually committed? That seems much broader, truly preemptive.
That's Section 126. Security for keeping peace in other cases, purely preemptive. An executive magistrate gets information that any person is likely to commit a breach of the peace or disturb public tranquility, or do any wrongful acts that may probably occasion such disturbance. If they think there's sufficient ground, they require the person to show cause why they shouldn't execute a bond for keeping peace.
How long can this preemptive bond last? And where can proceedings be initiated?
Up to 1 year. Proceedings can start where the disturbance is apprehended or where the person likely to commit it resides. Offers flexibility. The object is proactive, prevent disturbances before they happen, based on credible apprehension. Essential for public order, upholding salus populi suprema lex esto. Significant preventive power must always balance with liberty.
And what about people using platforms to spread harmful messages, inciting violence, for example? Does the law address them preventively?
Yes, Section 127 specifically deals with security for good behavior from disseminators of certain matters. If an executive magistrate gets info about someone intentionally disseminating or abetting matter, punishable under specific BNS sections, public order, incitement, judge defamation, obscenity, or circulating obscene matter, the magistrate can require them to show cause for a good behavior bond. Targets the source of potential disruption via speech.
Is there a specific period? And any special considerations for the press, given their role?
Bond is up to 1 year. And yes, crucial safeguard in 127 generally. No proceedings shall be taken against the editor, proprietor, printer, or publisher of any publication registered under the Press and Registration of Books Act for its content, unless ordered by the state government or empowered officer.
Protecting press freedom.
Yes, a delicate balance. Prevent harmful speech while protecting press freedom. Ensures journalists aren't arbitrarily targeted for reporting or commentary. Upholds Article 19 rights.
What about individuals just acting suspiciously, trying to hide, even if no specific crime yet? Can the law intervene preemptively?
That's Section 128. Security for good behavior from suspected persons. If an executive magistrate gets info that someone is taking precautions to conceal his presence, and there's reason to believe he's doing so with a view to committing a cognizable offense, the magistrate can require a show cause for a good behavior bond.
Also for a year.
Also up to 1 year. The object is preventive. Targeting individuals whose suspicious conduct strongly suggests impending serious crime. Allows preemptive intervention based on credible apprehension.
Finally, what about known habitual offenders? Posing a continuous, documented threat. How does the law handle such persistent dangers?
Section 129. Security for good behavior from habitual offenders. A robust preventive measure. Protects society from those with a persistent, proven record of serious crime. An executive magistrate requires show cause if they get info the person is habitually involved in specific serious crimes.
Like what kind of crimes?
Comprehensive list. Habitual robber, housebreaker, thief, forger. Habitually receiving stolen property, protecting thieves, habitually committing kidnapping, extortion, cheating, mischief, certain BNSS offenses, habitually breaching peace, habitually committing offenses under specific acts, drugs, foreigners, customs, food safety, etc. Or if the person is so desperate and dangerous as to render his being at large without security hazardous to the community.
That last one, desperate and dangerous, sounds very broad, potentially open to interpretation. How long can this bond be for, reflecting the gravity?
This is the most expensive preventive bond, up to 3 years. Reflects the gravity and persistent nature of the threat. The object of Section 129 is a strong legal mechanism to protect society from individuals with a pattern of serious crime, even if not currently charged. Significant preventive justice, prioritizing community safety, balancing liberty with the community's right to live without fear.
Okay, concrete illustration for 129. A known leader of a sophisticated criminal gang. Not currently charged, but intel, criminal history, reputation indicate their freedom poses a significant immediate hazard, intimidation, extortion, orchestrating future crimes.
Right.
Executive magistrate gets sufficient info, conducts inquiry, initiates proceedings to require this person execute a good behavior bond for, say, 3 years. Aims to incapacitate their ability to commit further offenses by placing them under legal restraint without waiting for the next crime.
Exactly. A powerful tool to disrupt ongoing criminal enterprises preventively.
Okay. The process for initiating and managing these bonds is critical for due process, preventing arbitrary use. That's the show cause procedure, starting with Section 130.
Correct. Lays out the precise legal steps.
What's the initial formal step a magistrate takes when deciding a bond might be needed, not just an informal request?
Not at all. When a magistrate decides to require show cause under 126, 127, 128, or 129, they shall make an order in writing. This formal order initiates proceedings and must clearly state 1. The substance of the information received, transparency. 2. The amount of bond. 3. The term it's in force. 4. The number of sureties, considering their fitness.
Warrant specific.
Yes. The object, formally initiate, inform the person of allegations and proposed action. Adheres to natural justice, know the case against you, prepare a defense.
How is this formal order then communicated, especially if they're not present in court?
Sections 131 to 133 cover communicating the order. If present, read over or explained. If not present, summons issued for appearance. If in custody, warrant issued to bring them.
Is there an emergency arrest option?
Yes, a critical immediate arrest proviso in Section 132. If info suggests immediate fear of a breach of the peace, preventable only by immediate arrest, magistrate, recording reasons, can issue an arrest warrant. Every summons or warrant must include a copy of the show cause order. Ensures full awareness.
Can a person avoid appearing personally? Maybe they're sick or have a lawyer?
Yes, Section 134, dispensing with personal attendance. Magistrate, if he sees sufficient cause, can permit appearance through an advocate, accommodates practical difficulties, ensures legal representation without mandatory presence, facilitates due process, prevents hardship.
After the order is communicated, what's the core proceeding? Is the information just assumed true, or is there an actual investigation?
This is the crucial inquiry into truth of information under Section 135. Once order, read, or person appears, magistrate shall proceed to inquire into the truth of the information and to take such further evidence as may appear necessary. Mandatory inquiry. Ensures allegations substantiated by evidence, not presumed. Fundamental check on preventative power.
How is this inquiry conducted? Full trial rules, something simpler.
Section 135(2) says inquiry shall be made as nearly as may be practicable in the manner prescribed for conducting trial and recording evidence in summons cases.
Okay, so establish judicial standards.
Yes. Reinforces fairness, minimizes arbitrary action. Not a full criminal trial, but far from casual assessment.
What if during this inquiry, while truth is still being determined, there's an immediate, urgent threat? Can the magistrate act instantly?
Yes. Section 135(3) provides for an interim bond during inquiry. If magistrate considers immediate measures are necessary for the prevention of a breach of the peace or commission of any offense during inquiry, they can, recording reasons, direct an interim bond for peace or good behavior until inquiry concludes. Can even detain until bond executed or inquiry ends. Powerful temporary measure for genuine emergencies.
Are there limits on this interim bond so it doesn't become overly punitive before a final decision?
Yes, important provisos. For example, no good behavior bond at this interim stage unless proceedings are under 127, 128, or 129. Also, interim bond conditions cannot be more onerous than those specified in the original Section 130 order. Prevents interim measure becoming unduly punitive or exceeding original scope.
For habitual offenders, how is their habitual nature proven? Just past convictions? Or can community perception play a role?
Section 135(4) clarifies. For habitual offenders, Section 129, being habitual or desperate or dangerous, quote, may be proved by evidence of general repute or otherwise.
General repute. Interesting.
Yes. Acknowledges pattern of behavior and public perception, often based on history, can be established through credible community input, intelligence, not just specific convictions. Reflects practical realities of dealing with known serial offenders.
Is there a time limit for these inquiries? Can they drag on indefinitely?
Yes, vital safeguard. Time limit for inquiry under ANUCHA 35(6) and 7. Inquiry shall be completed within 6 months from commencement. If not, proceedings shall stand terminated, unless magistrate, for special reasons recorded in writing, directs otherwise.
And detention also ends.
Crucially, yes. Any detention pending inquiry also terminates after 6 months. Sessions judge can vacate an extension if not based on special reasons, prevents indefinite preventive detention on unproven allegations, reinforces right to liberty, ensures timely justice. The object and theory behind this inquiry process ensure extraordinary power of preventive detention security isn't exercised arbitrarily. Formal judicial review, natural justice, due process, affirming liberty, ensuring measures are proportionate and time-bound.
These are clearly powerful tools, but with important consequences and safeguards. Let's delve into consequences and safeguards of security bonds. What happens once a bond is ordered or if it's not complied with?
Indeed. Following the inquiry, Section 136, order to give security. If inquiry proves necessity for peace good behavior, magistrate shall make an order accordingly for the bond. Mandatory outcome once necessity established.
Are there limits on bond amount or period? Can it be arbitrarily high or long?
Absolutely. Critical proportionality safeguards. Proviso states, no person shall be ordered to give security of a nature different from, or of an amount larger than, or for a period longer than, that's specified in the original Section 130 order.
Okay, can't exceed the initial proposal.
Right. Also, bond amount shall be fixed with due regard to the circumstances, and shall not be excessive. For minors, bond executed only by their sureties, recognizing limited capacity. Ensures measure is proportionate, not unduly burdensome or punitive.
What if the inquiry doesn't find a need for a bond? What happens then?
Section 137, discharge of person. If inquiry doesn't prove necessity, magistrate records this, discharges the person. If in custody only for inquiry, immediately released. Fundamental justice. If necessity not proven, liberty fully restored. Upholds presumption of innocence.
When does the bond period actually start? Immediately. Can it be deferred?
Section 138, commencement of bond period. If person already imprisoned, bond period shall commence on the expiration of such sentence, prevents concurrent periods, other cases, commences on date of order unless later date fixed for sufficient reason, offers practical flexibility.
What exactly does the bond obligate the person to do, practically?
Section 139, contents of bond, binds person to keep the peace or to be of good behavior. For good behavior, bond, commission, attempt, or abetment of any offense punishable with imprisonment wherever it may be committed is a breach.
Any imprisonable offense breaks it.
Yes, not limited to specific jurisdiction or offense type, broadens deterrent effect.
Who decides if a surety is fit? Just financial capacity.
Magistrate has power to reject sureties under Section 140. Can refuse reject surety deemed unfit, but not arbitrary. Before refusal, magistrate shall either himself hold an inquiry on oath into the fitness or cause such inquiry to be held by a subordinate.
Due process for the surety, too.
Yes. Reasonable notice given to surety and person they stand for. Reasons for rejection recorded. Ensures transparency. Prevents unsuitable sureties undermining the system. Ensures security is genuine.
What happens if someone just fails to provide security? Or worse, breaches their bond later?
That leads to imprisonment in default of security. Section 141 provides the teeth. If security not given by due date, person shall be committed to prison or detained if already in prison until period expires or security given. If peace bond breached, magistrate can order arrest and detention until bond period expires, without prejudice to other punishment forfeiture for the breach itself.
What if the bond period is long, over a year, and they default?
If security is for a period exceeding 1 year and not given, magistrate refers proceedings to sessions judge for review. Sessions judge examines, gives hearing, passes appropriate orders, imprisonment not exceeding 3 years, provisions for transfer to additional sessions judge. Also, if security tendered to jail officer, matter referred back to ordering court.
What kind of imprisonment is it for these defaults? Simple. Rigorous.
Section 141, 7 and 8 clarify. Imprisonment for failing peace bonds shall be simple. For good behavior bonds, simple if under Section 127, disseminators. For Sections 128, suspected, or 129, habitual, can be rigorous or simple as the court directs, reflecting varying seriousness. The object deter noncompliance, ensure effectiveness of preventive orders, even if it means temporary deprivation of liberty balanced by safeguards and time limits.
While the law allows detention, it also includes mechanisms for review and release, right? Section 142, power to release persons, modify orders, adds flexibility.
Yes, it's crucial. Introduces flexibility and judicial discretion.
So someone imprisoned for failing to give security can be released early. That seems like an important safety valve.
It is. District magistrate for executive magistrate orders or chief judicial magistrate, other cases, can, if they opine the person may be released without hazard to the community, order discharge. Critical safety valve. Prevents unnecessary preventive detention if risk genuinely diminishes. Balances state power, individual liberty.
Can the bond conditions themselves be changed? Amount reduced after issue?
Absolutely. High Court, Court of Session, or DMCJM for lower court orders may make an order reducing the amount of the security or the number of sureties or the time for which security has been required. Allows proportionality, adjustment based on evolving circumstances, ensures bond remains appropriate.
Can these discharges be conditional if there's still some lingering concern?
Yes. Sections 142(3)-8 cover conditional discharge. Discharge can be without conditions or upon any conditions which such person accepts. Conditions cease when bond period expires. State government may prescribe rules. If condition unfulfilled, magistrate can cancel discharge.
And then rearrest.
Yes. If canceled, person can be arrested without warrant, brought before magistrate. Unless fresh security given for unexpired term can be remanded to prison for that remainder. Intricate mechanism. Ensures flexibility, but public safety purpose remains paramount. Nuanced approach to rehabilitation, risk management.
Can the bonds themselves be canceled? Maybe circumstances change drastically.
Yes. Sections 142(9) and 10 allow cancellation of bond. High Court Court of Session may at any time, for sufficient reasons, recorded in writing, cancel any bond. DMCJM can do so for bonds under their orders. Crucially, a surety can also apply to the court to cancel a bond.
What happens if a surety applies to cancel?
Court shall issue a summons or warrant, requiring the person for whom such surety is bound to appear.
And if a bond is canceled, say because a surety backs out, does the preventive measure just end?
No, not necessarily. Section 143, security for unexpired period. When person appears after cancellation, magistrate court shall cancel the bond executed by such person and shall order such person to give for the unexpired portion fresh security of the same description.
So they need new security for the remaining time.
Exactly. Ensures continuity of preventive measure for intended period. Maintains protection deemed necessary while adapting to changes. The object of all these powers, release, modify, cancel, is critical flexibility and judicial discretion. Prevents undue hardship, unnecessary detention, while ensuring public safety, allowing adaptation. Embodies legal theory. Justice must be firm and merciful, capable of correction and adaptation. Prevents abuse of preventive power without compromising its goal of public order.
What a journey. We've really peeled back the layers on how our legal system compels evidence, meticulously tracks down proceeds of crime across borders, and takes these incredibly proactive steps to maintain peace and good behavior, from a simple summons to intricate international forfeiture and the nuanced application of security bonds. These provisions are truly the unseen gears of justice, constantly at work.
Indeed. And understanding these detailed mechanisms isn't just, for legal professionals. It highlights that delicate, often challenging balance between the state's legitimate powers to investigate and protect and the fundamental rights of individuals, privacy, liberty, due process. Knowing these legal ingredients, their interpretations, the underlying theories, offers you, the listener, a clearer lens, a way to view legal news, understand the fabric of law and order, appreciate the complexities involved in ensuring both safety and freedom in our dynamic society.
So as we reflect on these extensive powers granted to courts and officers, but coupled with vital safeguards like mandatory witnesses, judicial review, appeal processes, it raises an important question for all of us, really. In an era of rapidly evolving technology, especially with AI, new forms of digital communication, and with globalized crime becoming ever more sophisticated, how well do these traditional and newly adapted legal frameworks truly stand up to the challenges of today and tomorrow, ensuring both effective justice and the unwavering protection of individual liberties?
Imagine you're standing at the crossroads of everyday life and the intricate world of legal procedures. How do you ensure your family is supported when things go wrong? What happens when public peace is threatened and, authorities need to step in?
Right. How does the system respond?
And what exactly goes on behind the scenes when the police investigate a crime? I mean, from the moment it's reported right through to the final court submission.
Yeah, the whole process.
Today, we're taking a deep dive into some fundamental, yet often surprising, aspects of legal frameworks. We're focusing specifically on key excerpts from maintenance, public order, and police investigation procedures.
Indeed. And you've brought us a fascinating collection of sources here. They offer a really candid window into how the legal system tries to balance, individual needs with the broader demands of societal order.
Balancing act.
Definitely.
Right.
Our mission today is to extract the most important nuggets from these chapters, giving you a clear, structured understanding of these vital processes. We'll not just explore what the law says, but also try to peel back the layers to understand why these provisions exist and, crucially, how they're applied in often complex, real-world scenarios.
Think of it as getting a behind-the-scenes pass to the very mechanisms that, well, maintain a stable society. We're going to cover everything from who is obligated to pay maintenance and, what happens if they don't, to how police officers are instructed to handle everything from unruly gatherings to the most complex criminal investigations.
Covers a lot of ground.
Get ready for some crucial insights and perhaps a few things that will genuinely surprise you. All right, let's kick things off with something that touches so many lives. The legal safety net for dependents.
Okay.
We're getting into Chapter X, Sections 144, 147, which is all about orders for maintenance. Now, the core idea here from Section 144 seems to be about, well, a safety net. Can you elaborate on this?
Sure. What's truly foundational in Section 144 is its establishment of a clear legal obligation.
Right, legal.
Exactly, not just a moral suggestion. An obligation for individuals with sufficient means to financially maintain dependents who are unable to maintain themselves.
Okay, so unable to maintain themselves, that's key.
That's the key condition, and the law explicitly steps in when there's proof of neglect or refusal. This is really the bedrock for ensuring basic welfare and preventing vulnerable individuals from being left without support.
So it's a statement about responsibility.
It's a powerful statement, I think, that societal stability begins with individual responsibility, legally enforced.
So who exactly does this safety net cover?
Yeah.
It sounds like it might be broader than just, current spouses.
Absolutely. The scope is quite comprehensive. It reaches beyond maybe conventional expectations. First, it covers wives.
Okay.
And this is a crucial modern interpretation. The law explicitly states wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried.
That's huge. So divorce isn't necessarily the end of that obligation.
Not automatically, no. This significantly broadens the legal responsibility. It acknowledges that financial obligations can persist even after the marriage ends, especially when one party remains financially vulnerable.
That makes sense. What about children?
For children, the law is notably inclusive. It covers both legitimate and illegitimate children, whether married or not, as long as they are unable to maintain themselves.
Regardless of marital status of the parents.
Exactly. It reflects a deep commitment to the welfare of all offspring. And what's particularly, I think, forward-thinking is the provision for adult children with disabilities.
Oh, interesting. Tell me more about that.
Well, this refers to legitimate or illegitimate children, though it excludes married daughters who have reached adulthood but are unable to support themselves due to a physical or mental abnormality or injury.
So the law recognizes long-term needs there.
It's a clear recognition of long-term dependency needs and the extra support required for individuals facing those kinds of special circumstances. It really underscores a humanitarian approach within the legal framework.
And it also covers parents, right? That's not something everyone might immediately think of as a legal obligation from their kids.
Indeed, it does. It extends to parents, both fathers and mothers, who are unable to maintain themselves.
Wow.
So it establishes this kind of reciprocal duty, ensuring that children, when they are capable, also have a legal obligation to support their elderly or infirm parents.
So it turns family values into law, in a way.
It reinforces those deeply ingrained societal values of family care, essentially turning them into a legal mandate.
So if a dependent proves neglect or refusal, what's the magistrate's role here? Is it just like a suggestion?
Oh, not at all. A magistrate of the first class has the explicit authority to order a monthly allowance.
A specific amount?
At a rate they deem fit, yes. But this isn't merely advisory. It's a legally binding order with the full force of law behind it. It ensures tangible relief.
Okay, binding. Now here's where it gets really interesting, especially thinking about immediate relief. Legal processes can be, well, notoriously slow. They can't. So what mechanisms exist to prevent vulnerable parties from suffering while the main case is being decided?
This is where the concept of interim maintenance becomes absolutely vital.
Ingram, okay.
During the pendency of proceedings, while the case is ongoing, the magistrate can order immediate interim maintenance and even cover the expenses of such proceeding.
So help with legal costs, too.
Potentially, yes. And this isn't just a technicality. It's a recognition that, justice delayed can be a justice denied, especially for the financially vulnerable.
Right. People need to survive during the process.
Exactly. The law prioritizes survival during these legal battles. It prevents the process itself from becoming a weapon. And what's more, the law emphasizes urgency. It states that applications for interim maintenance should ideally be disposed of within 60 days.
60 days. That says a clear expectation.
It does. It underscores the importance of swift action in these situations.
What happens if someone is ordered to pay and they just don't? What are the consequences of noncompliance? We hear about that happening.
Yes, and Section 144.3 outlines some pretty robust enforcement mechanisms. If an ordered person fails to comply without sufficient cause, the magistrate can issue a warrant to levy the amount due.
Like collecting fines.
Similar to that process, yes. But it goes further. Non-payment can lead to imprisonment.
Imprisonment? Right.
Yes, for up to 1 month for each month's allowance that remains unpaid after the warrant's execution or until the payment is actually made.
Wow, okay. That underscores the seriousness of these orders.
It absolutely does. It serves as a strong deterrent against noncompliance.
Is there any time limit on seeking this enforcement? Like if someone waits years?
Yes, there's a limitation. No warrant can be issued for recovery of any amount due after 1 year from the date it became due.
Okay, so you need to act relatively quickly.
It encourages timely action on the part of the beneficiary, yes.
Are there ever situations where a wife might lose her right to maintenance or are disqualified?
Yes. The law is quite specific in Sections 144 and 5. A wife is not entitled to maintenance if she is, for example, living in adultery.
Okay. Or if she refuses to live with her husband without any sufficient reason.
Sufficient reason seems like a key phrase there.
It is. Or if they are living separately by mutual consent. And if an order has already been made and then proof emerges of these conditions.
Like adultery later on?
Yes, then the magistrate shall cancel the order. It's mandatory.
So, without sufficient reason is crucial. But what if the husband's actions are the reason she's refusing to live with him?
Precisely. And the explanation clarifies this. If a husband has contracted another marriage or keeps a mistress, this is explicitly defined as just ground for his wife's refusal to live with him.
Ah, so that protects her, right, in those cases?
Absolutely. In such cases, her right to maintenance is preserved, even if she lives separately. This part of the law carefully defines circumstances where marital breakdown impacts financial obligations, acknowledging factors like infidelity and, striving for fairness. It's fascinating how many specific scenarios are anticipated by the law. Now that we understand who is covered and the obligations, the next logical question is, how do you actually initiate this process? What makes it accessible?
That brings us neatly to Section 145, which covers the procedure. And what's particularly flexible here is the jurisdiction.
Where you can file the case.
Exactly, where you can initiate proceedings. They can be started in a district where the person liable for maintenance resides.
Okay.
Or where that person or his wife resides, or where he last resided with his wife, or with the mother of the illegitimate child, or even where his father or mother resides.
Wow, lots of options. Why so flexible?
This flexibility is critical. It aims to make it easier for the aggrieved party, often the one in a more vulnerable position, to seek remedy. It recognizes families might live in different locations, so it reduces barriers to justice. It's a practical measure.
What about due process? How is evidence handled? And what if someone tries to, avoid the whole thing?
Due process is paramount here. All evidence must be taken in the presence of the person against whom the order is sought, or their advocate.
Okay, so they get their say.
They do. But the law anticipates evasion. If someone is found to be willfully avoiding service or willfully neglecting to attend, the magistrate can proceed ex parte.
Meaning without them?
Without their presence, yes. But there's a safety net. Such an ex parte order can be set aside if the person shows good cause within 3 months.
So it balances efficiency with fairness.
Exactly. It balances the need for justice to proceed with safeguards against genuine non-attendance. And the court also has the power to make orders regarding costs, aiming for fairness in legal expenses.
So an order is issued, but life isn't static, right? Incomes change, people's needs evolve. Does the law allow for adjustments, or is it a rigid one-time decision?
That's where Section 146, Alteration and Allowance, comes in. And this is a vital provision because it acknowledges life isn't static. A magistrate can alter the monthly allowance, either increasing it or decreasing it, upon proof of a change in the circumstances of either the person receiving or the person paying.
Ah, okay. So it can go both ways.
It can. This prevents maintenance orders from becoming rigid and potentially unfair over time. It reflects changes in income, health, needs. It ensures the law remains responsive to changing realities.
Does it interact with other court decisions?
Yes, it also ensures consistency. If a competent civil court makes a decision that affects the maintenance order, the magistrate shall cancel or vary their order accordingly.
Okay. And it also specifies the definitive end of maintenance obligations for divorced women, which seems important for clarity and closure.
Exactly. Section 146.3 is quite specific about this. If a divorced woman remarries, her order is canceled from the date of remarriage.
Makes sense.
Similarly, if she receives a lump sum settlement under customary or personal law upon divorce, or if she voluntarily surrenders her rights after divorce, the order is canceled.
So clear endpoints.
These clauses provide clear parameters, preventing indefinite liability. And it also avoids any double dipping, as any maintenance paid under this section must be factored into any civil court decree for maintenance or dowry.
Finally, for this chapter, how is a maintenance order actually enforced, especially if people move around? That seems like a practical challenge.
That's the power of Section 147, enforcement of order of maintenance. First, the person in whose favor the order is made gets a copy without payment, ensuring they have the legal document.
Good accessibility.
Crucially, such an order may be enforced by any magistrate in any place where the person liable may be found upon proof of identity and non-payment.
Any place. So across district lines.
Yes. This interjurisdictional enforceability is vital. It means a maintenance order isn't restricted by geographical boundaries within the legal system. If someone moves to another district or even state, the order can still follow them.
That significantly enhances its effectiveness.
It does. It protects the beneficiary and makes the order much more practical.
That wraps up our deep dive into maintenance orders. Really important stuff. Now, let's pivot to something entirely different, but equally crucial for societal stability. How public order is maintained.
Okay.
When a gathering threatens to spiral out of control, how does the state protect the collective? We're moving into Chapter 11, Sections 148, 27, 67, starting with unlawful assemblies.
Right. This section deals with the immediate response to gatherings that pose a threat to public peace. It's about proactive intervention by authorities, carefully balancing the right to assembly with the need for public safety.
Section 148. Dispersal of assembly by use of civil force sounds like the first line of defense. Who has the power to act here?
Well, it can be any executive magistrate, an officer in charge of a police station, or even a police officer not below the rank of sub-inspector.
Okay, several levels of authority.
Yes. They have the power to command an unlawful assembly, or, more broadly, any assembly of 5 or more persons likely to cause a disturbance of the public peace to disperse.
And people have to obey.
The law is clear. Members of such an assembly have a legal duty to disperse accordingly. If they don't, or if they show a, quote, determination not to disperse.
They're refusing.
Exactly. Then the same officers can use force to disperse them. And they can even require assistance from other persons, though not armed forces personnel acting as such, to help in dispersal and arrests.
So, like a protest turning disorderly, this provides the legal basis for police stepping in.
Precisely. That's the scenario this section addresses.
But when civil force isn't enough, things get incredibly serious. How does the law escalate its response? And what are the ultimate safeguards when armed forces become involved? That takes us to Section 149.
This is indeed framed as a measure of last resort, and the law imposes very strict conditions. The armed forces can only be used if the assembly cannot otherwise be dispersed.
Only if other means fail.
Yes, and importantly, it is necessary for the public security that it should be dispersed. This really highlights the sheer gravity of involving military personnel in internal matters.
Who makes that call?
The district magistrate, or an authorized executive magistrate, is the only authority who can order dispersal by the armed forces if they are present.
And are there limits on the force they can use?
Absolutely. This is critical. Section 149.3 contains a crucial safeguard. The armed forces officer must obey the order, but they are legally bound to use as little force, and do as little injury to person and property as may be consistent with dispersing the assembly and arresting and detaining such persons.
The principle of proportionality.
Exactly. That principle of proportionality of force is paramount, even in such severe circumstances. It underscores the legal imperative for minimal harm. It's a carefully balanced approach. Last resort, civilian authority, and minimal force.
So even in the most extreme situations, there are clear legal limits. But what if there's no magistrate around and public security is in immediate peril? Section 150 seems to address this kind of emergency.
That's precisely what Section 150 covers, emergency action. When public security is manifestly endangered and no executive magistrate can be communicated with.
A real crisis moment.
Yes. In that situation, any commissioned or gazetted officer of the armed forces can disperse such an assembly and arrest individuals. This grants emergency powers to military officers for those immediate critical situations.
But does civilian control eventually come back?
Yes, that's key. To maintain the fundamental principle of civilian authority, the officer must establish communication with an executive magistrate as soon as it becomes practicable, and from then on, obey the magistrate's instructions.
So it ensures a return to civilian control.
As soon as the immediate crisis allows, yes.
Given these highly volatile situations, you'd imagine there needs to be some protection for those acting in good faith, right? That's where Section 151, protection against prosecution, comes in.
This provision is vital for those on the front lines, making difficult detentions under pressure. No prosecution can be instituted in a criminal court against armed forces personnel involved in these actions without central government sanction.
Okay, high-level approval needed.
Yes. Or against others, like police or magistrates, without state government sanction. This sanction requirement acts as a check against arbitrary action or, frivolous complaints.
And what about their actions themselves?
Critically, executive magistrates, police officers, armed forces officers, and even members who are just obeying orders, if they are acting in good faith under these sections, are not deemed to have committed an offense.
Good faith is the standard.
It is. This provides necessary legal protection, recognizing the difficult split-second decisions they might face, while the sanction requirement still acts as an important safeguard against abuse of power.
Moving on from large assemblies to more localized issues, we now enter the realm of public nuisances with Section 152, conditional order for removal of nuisances. This sounds like how authorities deal with problems that harm the community directly.
Indeed, this section empowers specific executive magistrates, district magistrates, subdivisional magistrates, or others specially empowered to act. They can act based on a police report or other information and after taking evidence if they deem it necessary.
What triggers this? What kind of nuisances are we talking about?
It triggers action when certain conditions related to public nuisance or danger exist. The law covers a broad range of harms. Unlawful obstructions in public places like roads or rivers.
Okay.
Trades or occupations that are injurious to public health or comfort.
Right.
Think maybe noisy factories or polluting businesses.
Right.
Construction or disposal of substances likely to cause a fire or explosion. Dangerous buildings or even trees likely to fall and cause injury.
Unsafe structures.
Exactly. Or unfenced tanks or wells near public places. Even dangerous animals that need to be dealt with.
So pretty wide-ranging potential harms.
Very much so.
Yeah.
Imagine a dilapidated building about to collapse onto a public street or a factory polluting a river used by the public. This section empowers swift action.
And what's the immediate action a magistrate can take? What's this conditional order?
They can issue a conditional order. This requires the person responsible to remedy the situation, say, remove that obstruction, stop the harmful trade, repair the building within a time to be fixed in the order.
Okay, so a deadline.
Yes. But the person has an alternative. They can appear before the magistrate and show cause why the order shouldn't be made absolute, why they shouldn't have to comply.
So they get a chance to argue their case.
They do. But what's crucial here is the immediate and executive nature of these initial orders. Section 152 states that no order properly made under this section can be questioned in any civil court.
Wow, so it bypasses the civil courts for speed.
For this initial phase, yes, ensuring quick action for public safety. The law also ensures proper notification, either through personal service or public proclamation if the person can't be found easily.
And what if that person just ignores the conditional order entirely? Doesn't fix the problem, doesn't show up to argue?
If the person neither performs the required act nor shows cause against the order, they become liable to penalties under Section 223 of the Bhartiya Nagrik Suraksha Sanhita 2023, that's India's new criminal code.
So there are real teeth to it.
Yes. And the conditional order then becomes absolute. This links directly to the ultimate enforcement.
What if they still don't comply after it's absolute?
Then Section 160 kicks in. The magistrate can actually cause the act to be performed themselves, get the building repaired, sense the well, and recover the costs from the person responsible, even by selling their property if necessary.
So the authorities can step in and fix it directly.
They can. And for truly urgent, imminent dangers, Section 161 allows the magistrate to issue an immediate injunction, taking preventive measures without even waiting for the full show cause inquiry under Section 157 to conclude. It's about averting immediate crisis.
So the system is really designed for swift action on these nuisances. But what about truly urgent situations that demand immediate executive action without even that initial conditional order and show cause process? That sounds like Section 163. Power to issue order in urgent cases of nuisance or apprehended danger. This seems like it grants pretty broad power.
This section indeed grants broad, swift, temporary executive power to magistrates, precisely for those urgent cases.
What qualifies as urgent?
It applies when a magistrate believes there's sufficient ground and that immediate prevention or speedy remedy is desirable. Desirable to prevent things like obstruction, annoyance, danger to life, health, or safety, or a disturbance of public tranquility, a riot, or an affray.
So pretty serious potential outcomes.
Very serious. In such cases, the magistrate can issue a written order stating the material facts, directing a person to abstain from a certain act or take specific action regarding property in their possession or management.
Can these orders be issued without the person even being present or notified first? That seems like a significant amount of power.
Yes, in cases of emergency or when notice cannot be served in time to prevent the danger, orders can be passed ex parte, meaning without the person's presence or hearing. This reflects the critical nature of the situations this section aims to address, preventing immediate harm. The orders can be directed to specific individuals or people residing in a particular area or even the public generally when frequenting a specific place.
That's incredibly broad. Are there checks on this power?
Yes, this broad power is balanced by strict timelines and review mechanisms. An order under Section 163 remains in force for not more than 2 months.
Okay, time limited.
Yes, although the state government can extend this period up to 6 months if they believe it's necessary to prevent danger to human life, health, or safety, or to prevent a riot or fray, and they have to publish a notification specifying their reasons.
And can the orders be challenged?
Absolutely. Any magistrate, or the state government itself, can rescind or alter an order, either on their own motion or on the application of any person aggrieved. And if someone applies, they must be given an early opportunity of appearing and showing cause against the order. So there's a review process built in.
So it's different from the Section 152 process for existing nuisances.
Yes, it's distinct. Section 152 deals with removing existing proven nuisances after a show cause process. Section 163 is about urgent preventive measures to stop apprehended danger immediately, often before harm occurs, hence the ex parte power and shorter initial duration.
Moving on to another common source of conflict that can quickly escalate: disputes over immovable property. Section 164 deals with procedure, where dispute concerning land or water is likely to cause breach of peace. This seems specifically designed to prevent violence breaking out over property.
This is a crucial section for maintaining peace in the community. It's triggered when an executive magistrate is satisfied, usually from a police report or other information, that a dispute likely to cause a breach of the peace exists concerning any land or water within their local jurisdiction.
What counts as land or water?
The term is broadly defined. It includes buildings, markets, fisheries, crops, other produce of land, and even the rents or profits from such property.
Okay, so it covers a lot. What does the magistrate do then?
The magistrate issues a written order stating the grounds for their concern and requires the parties involved in the dispute to attend their court and submit written statements of their respective claims as respects the fact of actual possession of the property.
Actual possession. So the magistrate isn't trying to determine who owns the land.
Precisely. That's the critical distinction. The magistrate will peruse the statements, hear the parties, take evidence, and then decide who was in actual possession on the date the initial order was made, without reference to the merits or the claims of any of the parties to a right to possess.
So ownership is for the civil courts later.
Exactly. This procedure effectively prevents potential violence arising from property disputes by temporarily settling the question of possession. It prioritizes keeping the peace over immediately resolving the underlying, often complex, property rights dispute.
What if someone was just kicked off the land right before this started?
There's a key proviso for that. If it appears to the magistrate that any party was forcibly and wrongfully dispossessed within 2 months before the date the police report was received, or after that date but before the magistrate's own order.
So a recent forceful eviction.
Yes. Then the magistrate may treat the party so dispossessed as if that party had been in possession on the date of the order. This protects victims of recent forceful eviction from losing out simply because they were physically removed just before the legal process began.
That seems fair. What happens once the magistrate decides who is in possession?
The magistrate issues an order declaring that party to be entitled to possession until evicted therefrom in due course of law, and they forbid all disturbance of that possession until such eviction. They can also restore possession to a party found to have been forcibly and wrongfully dispossessed under that proviso we just discussed.
So it freezes the situation based on recent possession until a civil court resolves the ownership.
Essentially, yes. It's a peacekeeping measure above all else.
And what if possession is really unclear or highly contentious, like maybe both parties have some claim or it's an emergency situation?
That's where Section 165 comes in. Power to attach, subject of dispute, and to appoint receiver. The magistrate can take this step if they consider the case one of emergency, or if they decide after making their initial order that none of the parties were actually in possession as defined in Section 164, or if they are unable to satisfy themselves as to which of them was then in possession.
So if possession is too murky to decide?
Exactly. In those situations, the magistrate can attach the subject of dispute, meaning they take temporary control of the property.
Why would they do that?
It provides a neutral solution. It prevents either party from exploiting the property or using it in a way that might escalate the conflict while the dispute is ongoing. The attachment remains until a competent court determines the rights of the parties.
Can the magistrate manage the property then?
Yes, they can make arrangements for its proper custody or upkeep, or even appoint a receiver to manage it. This receiver has powers similar to those appointed under the Code of Civil Procedure. However, the magistrate always defers to the civil court. If a civil court later appoints its own receiver for the property, the magistrate's receiver has to hand over possession and accounts.
So it's a temporary holding action, respecting the civil court's ultimate authority.
Precisely. The law also extends similar procedures under Section 166 to disputes concerning the right of use of land or water, things like easements or access rights. These disputes can be just as incendiary as ownership fights.
Right, fights over access.
Exactly. Again, the magistrate inquires into the claim of right and, if it exists, can issue an order prohibiting interference. But always, the focus remains on preventing a breach of the peace. And for all these property-related disputes, Sections 159 and 167 allow magistrates to direct local investigations or summon experts to gather on-the-ground information to help them make informed decisions.
We've covered a lot on maintaining order and resolving disputes.
Yeah.
Now let's shift gears completely to the very beginning of how police deal with crime. Preventive action of the police, covered in Chapter 12, Sections 168, 172. This is about stopping crimes before they happen.
This chapter is fundamental because it outlines the proactive duties of the police. It goes beyond merely investigating crimes after they occur, focusing on the critical role of preemption in maintaining public safety.
Section 168 states, police to prevent cognizable offenses. That sounds like a core mandate, very direct.
It absolutely is. This section mandates that every police officer may interpose for the purpose of preventing and shall, to the best of his ability, prevent the commission of any cognizable offense.
Remind us what cognizable means here.
A cognizable offense is one serious enough that the law allows a police officer to arrest the suspect without needing a warrant from a magistrate first.
Oh, serious crimes.
Yes. So this section imposes a fundamental, proactive duty on every officer. It underscores their role in maintaining safety by actively preempting crime and protecting the public.
How do they find out about potential crimes?
Well, Section 169 emphasizes intelligence. It requires any police officer receiving information about a design to commit any cognizable offense to communicate that information promptly to their superior officer and also to any other officer whose duty it is to prevent or take cognizance of such an offense.
So information sharing is key to prevention.
Crucial. It ensures vital intelligence is shared across the force to facilitate coordinated preventive action.
So if they know about a potential crime, can they just arrest someone to stop it? That sounds like Section 170. Arrest to prevent commission of cognizable offenses.
This grants significant preemptive power, yes, but with a crucial limitation. A police officer, knowing of a design to commit any cognizable offense, may arrest without orders from a magistrate and without a warrant the person so designing.
Okay, they can arrest the person planning it.
If, and this is the key part, if it appears to such officer that the commission of the offense cannot be otherwise prevented.
Only if arrest is the only way to stop it.
Exactly. It allows for swift intervention to avert an imminent crime. However, there's a strict safeguard for individual liberty built right in. Section 172 states that no person arrested under this section can be detained in custody for longer than 24 hours from the time of arrest,
24 hours max.
unless their further detention is required or authorized under any other provision of this code or any other law currently in force.
So it's a very temporary preventive detention.
Yes. It reflects a careful balance between the need for prevention and the protection of individual freedom from arbitrary detention.
And what about protecting public assets? Like stopping vandalism as it happens. Section 171 covers prevention of injury to public property.
This section gives police officers immediate authority to act on their own initiative. A police officer may, of his own authority, interpose to prevent any injury attempted to be committed, in his view, to any public property, whether it's movable or immovable.
So if they see someone spray painting a statue,
Exactly, or trying to remove or injure public landmarks, navigation markers, buoys, things like that. The officer can step in immediately to stop it without waiting for higher orders. It's about directly protecting shared assets.
and for all these preventive actions to work, the public needs to cooperate, right?
That's essential. Section 172 codifies this requirement. It states clearly, all persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter.
So you have to follow lawful police directions in these situations. What if someone doesn't?
If someone resists, refuses, ignores, or disregards such a lawful direction, Section 172 empowers the police officer to detain or remove that person. They can then either take the person before a magistrate or, in what the code calls petty cases, release them as soon as possible within a period of 24 hours.
Okay, so mechanisms to manage non-compliance.
Yes, it underpins the authority needed for police to effectively maintain public order and prevent crime, but with those built-in time limits for detention in minor cases.
So that covers prevention. Now let's move to Chapter 13, Information to the Police and Their Powers to Investigate. This outlines how crimes are actually reported and then probed by the police. We'll start with receiving information in Section 173. Information in cognizable cases. This is often the very first step in a criminal investigation, isn't it?
Exactly. This is where the formal legal process truly begins for serious crimes. A cognizable offense, again, is one where police can arrest without a warrant. Section 173 says information relating to such an offense can be given orally or by electronic communication to an officer in charge of a police station.
How is it recorded?
If given orally, it must be reduced to writing by the officer or under the direction, read over to the informant, and then signed by the person giving the information. If it's given by electronic communication, it needs to be taken on record by the officer, again, on the basis of a brief note, and it should be signed by the person making the communication within 3 days. The substance of all such information, whether written or oral, is then entered in a prescribed register kept at the police station, often called the station diary or general diary.
Now, this section has really evolved with some important modern safeguards, hasn't it? Especially for vulnerable victims. This seems like a key insight into how the law is adapting.
Absolutely, and this is a truly groundbreaking shift, reflecting a much greater sensitivity. There are several key provisos here. First, for information regarding certain offenses against a woman, the text lists specific sections of the Bhartiya Nagrik Suraksha Sanhita 2023 covering things like sexual assault, acid attacks, etc. The information must be recorded by a woman police officer or any woman officer.
That's a critical procedural safeguard.
It is. Furthermore, if the person giving the information is temporarily or permanently mentally or physically disabled, the information must be recorded by a police officer at the residence of the person or at a convenient place of their choice.
So they don't have to go to the station.
Exactly. And it must be done in the presence of an interpreter or a special educator as needed.
Providing necessary support.
Yes, and critically, the recording of such information shall be videographed.
Videographed. Wow.
Yes, and following that, the police officer shall get the statement of the person recorded by a judicial magistrate under Section 183 as soon as possible.
So multiple layers of protection and evidence gathering.
Precisely. This isn't just about recording information, it's about ensuring sensitivity, accuracy, and creating additional verifiable evidence, especially for vulnerable victims. It significantly enhances their access to justice and aims to prevent re-traumatization during the reporting process. The informant or victim also gets a copy of the recorded information free of cost, ensuring transparency.
That's a huge step toward centering the victim's experience and ensuring the integrity of the initial report. Now, what if the police refuse to record the information in the first place? Does the person reporting have any recourse?
Yes, there absolutely is a clear escalation path provided in Section 134. If an officer in charge of a police station refuses to record the information, the aggrieved person can send the substance of it, in writing and by post, to the superintendent of police concerned.
Okay, go up the chain of command.
Exactly. If the superintendent is satisfied that such information discloses the commission of a cognizable offense, they shall either investigate the case themselves or direct an investigation to be made by a subordinate police officer.
And if the SC doesn't act?
If the person is still aggrieved by the inaction of the police, even after approaching the superintendent, they can then make an application to the magistrate concerned under Section 175(3). So there's a judicial backstop.
That provides a clear route if initial reporting is obstructed. What about less serious offenses, non-cognizable ones?
For non-cognizable cases where police cannot arrest without a warrant, Section 174 applies. The information is still entered in the police register, but the informant is then referred to the magistrate. Police cannot investigate a non-cognizable case without an order from a magistrate. If they get such an order, they can investigate but still can't arrest without a warrant. If a situation involves both cognizable and non-cognizable offenses, it's treated as cognizable.
So a clear distinction in police powers based on the severity of the alleged offense.
Yes, very clear. Immediate autonomous power for serious cognizable crimes. Judicial instruction required for less serious non-cognizable ones.
Once information about a cognizable offense is received and processed, the investigation needs to be initiated. Section 175 covers the police officer's power to investigate a cognizable case. It sounds like they have autonomous power here.
This section grants significant autonomy, yes. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area of the station would have power to inquire into or try.
So they can just start investigating right away?
Generally, yes, for cognizable offenses within their jurisdiction. This allows for swift action on serious crimes, but it's not entirely unchecked. A proviso allows the superintendent of police, considering the nature and gravity of the offense, to require a deputy superintendent of police to investigate instead. So there's superior oversight.
Can an investigation be challenged just because a specific officer wasn't technically supposed to handle it?
No, Section 175(2) prevents that. An investigation can't be questioned simply because the officer wasn't empowered under the specific section to investigate. The focus is on whether an investigation happened, not a technicality about which specific officer did it.
And magistrates still have a role in ordering investigations?
Yes, Section 175(3) and 4 confirm that. Magistrates can order investigations based on those applications we mentioned from people aggrieved by police inaction, or when dealing with complaints against public servants, ensuring judicial oversight remains.
Once an investigation is initiated, there's a specific procedure for investigation detailed under Section 176. This sounds like the real nuts and bolts of what happens on the ground.
It is. If an officer in charge receives information or otherwise suspects a cognizable offense has been committed, one they are empowered to investigate under Section 175, they shall forthwith send a report to a magistrate who is empowered to take cognizance of the offense upon a police report.
So notify the judiciary immediately.
Yes. Then, the officer is required to proceed in person or depute a qualified subordinate officer to the spot to investigate the facts and circumstances of the case, and, if necessary, to take measures for the discovery and arrest of the offender.
Are there exceptions? Do they always have to go to the spot?
There are a couple of exceptions listed in the provisos to Section 176(1). First, if the information is against a named person and the case is not of a serious nature, the officer might decide they don't need to go in person or send a subordinate to the spot.
Okay, for minor specific cases.
Right. Second, if it appears to the officer that there is no sufficient ground for entering on an investigation, they shall not investigate the
But they
case.
have to justify not investigating.
Yes. For both these exceptions, the officer must state the reasons for not fully complying with the standard procedure in their report to the magistrate. And if they decide not to investigate at all, they must also notify the original informant of this fact and the reasons why.
And this section also includes those really important provisions regarding victims of rape and the use of forensic evidence, similar to what we saw in Section 173, right?
It does, reinforcing those crucial points within the investigation procedure itself. A further proviso mandates that the recording of a statement of a victim of rape or related offenses shall be conducted at the residence of the victim or in the place of her choice, and, as far as practicable, by a woman police officer in the presence of her parents, guardian, or a local social worker.
Using technology, too.
Yes, it explicitly states the statement may also be recorded through any audio, video, electronic means, including mobile phone. This emphasizes victim comfort, support, and evidence integrity.
And the forensic requirement.
That's in Section 176, a major addition. For offenses punishable with imprisonment for 7 years or more, the investigating officer shall cause a forensic expert to visit the crime scene to collect forensic evidence.
So mandatory forensic involvement for serious crimes.
Yes, and crucially, the expert shall also take videography of the process on mobile phone or any other electronic device. This ensures a transparent, verifiable record of evidence collection at the scene. If a state lacks forensic facilities, it can notify the use of facilities in another state.
That really mandates modern evidence-based investigation practices.
It does. It's a significant step towards strengthening prosecutions through reliable scientific evidence. These reports and procedures are then typically channeled through superior officers, as per Section 177, to ensure quality control before reaching the magistrate. Section 178 also confirms the magistrate's power to oversee the investigation, either directing it, holding their own preliminary inquiry, or deputing another magistrate to do so.
Moving into how evidence is actually gathered during the investigation, let's talk about witnesses. How does the law ensure witnesses cooperate without being unduly pressured or inconvenienced? Section 179 covers requiring attendance.
Right. Section 179 gives an investigating police officer the power to require, by order in writing, the attendance before themselves of any person residing within the limits of their own or any adjoining police station who appears to be acquainted with the facts and circumstances of the case. And the law states that person shall attend as required.
So they have to show up if summoned by the police. Are there protections?
Yes, there are very important safeguards, especially for vulnerable witnesses, laid out in the provisos. No male person under the age of 15 years or above the age of 60 years, no woman, and no mentally or physically disabled person or person with acute illness shall be required to attend at any place other than the place in which such person resides.
So police have to go to them.
Generally, yes, for these categories. However, a second proviso adds that such persons may be permitted to attend the police station if they are willing to do so, and their reasons are recorded in writing by the officer.
So it protects them from inconvenience or pressure, but allows voluntary attendance.
Exactly. It promotes cooperation while safeguarding rights. The state government can also make rules for paying reasonable expenses to witnesses who have to attend at a place other than their residence.
Once a witness attends, how are they questioned? That's Section 180, examination of witnesses by police.
The investigating officer, or a higher-ranking officer if requested, can orally examine any person supposed to be acquainted with the facts and circumstances.
Do they have to answer everything?
Section 182 says such persons are bound to answer truly all questions relating to the case put to them by the officer, except for questions the answers to which would have a tendency to expose them to a criminal charge or to a penalty or forfeiture.
The right against self-incrimination.
Precisely. That fundamental right is protected here.
How are these answers recorded?
The police officer can reduce any statement made during the examination into writing, and if they do so, they must make a separate and true record of the statement of each person whose statement they record.
Can they use technology?
Yes. Mirroring other sections, 183 states the statement may also be recorded by audio-video electronic means. And again, reinforcing victim protection, the statement of a woman against whom certain offenses, like sexual assault, are alleged shall be recorded by a woman police officer or any woman officer.
Okay, so multiple ways to record with specific protections. Now, how much weight do these police statements actually carry in court? Section 181, statements to police and use thereof, sounds like it clarifies their evidentiary value or lack thereof.
This section is absolutely crucial because it significantly limits the evidentiary value of statements made to the police during an investigation. Section 181 states that no statement made by any person to a police officer in the course of an investigation, if reduced to writing, shall be signed by the person making it.
Not signed. Why?
It's part of ensuring voluntariness and preventing pressure. And more importantly, the section states that such a statement, whether written or recorded electronically, shall not be used for any purpose, saving exceptions, at any inquiry or trial in respect of any offense under investigation at the time such statement was made.
So they can't just read the police statement out as evidence in court.
Generally, no. It cannot be used as substantive evidence, that is, evidence of the truth of the facts stated within it. This is a profound legal commitment, a safeguard against potential coercion or inaccuracies during police questioning.
Are there any uses for it in court?
Yes, the main exception is laid out in the proviso. If a witness whose statement was recorded by police is called for the prosecution in the trial, parts of their police statement can be used by the accused and, with the court's permission, by the prosecution, to contradict that witness under the provisions of the Bhartiya Nagrik Suraksha Sanhita 2023, the Evidence Act.
Ah, so for impeachment. To show the witness is saying something different now.
Exactly. It can be used to challenge the witness's credibility by pointing out inconsistencies between their police statement and their court testimony. An omission of a significant fact in the police statement might also amount to a contradiction. But it's not proof of the original statement's truth.
That's a critical distinction.
It is. And Section 182 further reinforces this principle by explicitly prohibiting any police officer or person in authority from offering any inducement, threat, or promise, as defined in the Evidence Act, to get someone to make a statement. Though, importantly, it also says no police officer should prevent someone from making a statement of their own free will. It's all about voluntariness.
But confessions can be powerful evidence if they are voluntary. How are they properly recorded with judicial safeguards to ensure that voluntariness? That seems to be the focus of Section 183, recording of confessions and statements.
This is a critical section dealing with the recording of potentially incriminating statements, but under judicial supervision, not police control. Any metropolitan magistrate or judicial magistrate, whether or not they have jurisdiction in the case, can record any confession or statement made to them during an investigation or at any time afterwards before the inquiry or trial begins.
So a magistrate does the recording, not the police investigating.
Correct. And crucially, Section 183(1)A explicitly states that a police officer on whom any power of a magistrate has been conferred cannot record a confession under this section. This maintains a clear separation between the police investigative role and the judicial recording role.
Can they use technology here too?
Yes. The first proviso to 183(1) states that any confession or statement may also be recorded by audio-video electronic means in the presence of the advocate of the person accused.
With their lawyer present. That's a significant safeguard.
A very significant safeguard for the accused.
How does the magistrate ensure the confession is truly voluntary?
Section 1833 lays this out clearly. Before recording any confession, the magistrate must explain to the person making it that they are not bound to make a confession, and that if they do, it may be used as evidence against them. The magistrate shall not record the confession unless, upon questioning the person, they have reason to believe that it is being made voluntarily.
What if the person refuses to confess at that point?
If at any time before the confession is recorded the person appears unwilling to make it, the magistrate shall not authorize the detention of such person in police custody. This prevents police from holding someone indefinitely hoping they'll confess to a magistrate.
How is the confession actually recorded?
It's recorded in the manner provided in Section 316 for recording the examination of an accused person. It must be signed by the person making the confession, and the magistrate then adds a memorandum at the foot of the record stating they explain the conditions, they believe it was voluntary, it was taken in their presence and hearing, read over to the person, and admitted to be correct.
What about non-confessional statements made to a magistrate?
Those are recorded differently under Section 183(4). They are recorded in the manner the magistrate thinks best fitted for the circumstances, and the magistrate has the discretion to administer an oath to the person making the statement.
Now, there are also specific groundbreaking provisions here for victim statements in serious cases, mirroring what we saw earlier, aren't there?
Yes, and this is where Section 183 becomes truly significant for victim protection and streamlining trials. Section 183 mandates that in cases involving certain serious offenses, particularly sexual offenses, the magistrate shall record the statement of the person against whom such offense has been committed as soon as the commission of the offense is brought to the notice of the police.
So very early on, a formal statement before a magistrate.
Yes. And the proviso states that, as far as practicable, this statement should be recorded by a woman magistrate or, if unavailable, by a male magistrate in the presence of a woman nominated by the magistrate.
What about support for disabled victims?
That's also mandated here, mirroring the provisions for initial information recording. If the victim is temporarily or permanently mentally or physically disabled, the magistrate shall take the assistance of an interpreter or a special educator in recording the statement. And, critically, such statements shall be recorded through audio-video electronic means, preferably by mobile phone.
And what's the legal effect of recording it this way with these supports?
This is the game changer. Section 183.6 states that a statement recorded under 183.6 for a disabled person, with the help of an interpreter or special educator and videographed, is considered a statement in lieu of examination in chief, as specified in Section 142 of the Bhartiya Nagrik Suraksha 2023, the Evidence Act.
In lieu of examination in chief, what does that mean practically?
It means that this initial statement recorded by the magistrate stands as the victim's primary evidence given in court. The prosecution doesn't need to re-examine the victim in chief at the trial. The victim can then be cross-examined on that statement directly.
Wow, that significantly streamlines the process and potentially reduces trauma for the victim.
Absolutely. It ensures their voice is heard accurately with appropriate support right at the beginning, and that initial recording carries significant evidentiary weight, preventing the need for them to repeat their main testimony later in court. It's a major step forward. The magistrate then forwards these recorded confessions and statements to the magistrate, who will actually inquire into or try the case.
Following the recording of statements, especially in sexual offense cases, medical examination is often crucial. Section 184 details the medical examination of victim of rape. What are the key procedures here?
This section standardizes a critical and sensitive process when, during an investigation of rape or attempted rape, the woman victim is examined by a medical expert. Section 184.1 mandates that this examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or a local authority.
So a government doctor, preferably.
Yes, or if they aren't available, then by any other registered medical practitioner, but with the crucial requirement of consent.
Consent is key.
Absolutely fundamental. Section 184 states the examination requires the consent of the woman or of a person competent to give consent on her behalf if she's unable. Section 184 reiterates emphatically that no examination is lawful without such consent. This is a non-negotiable protection of bodily autonomy.
How quickly should this happen?
The woman shall be sent to the registered medical practitioner within 24 hours from the time of receiving information relating to the commission of such offense, ensuring timeliness for evidence collection and care.
What does the medical report need to include?
Section 184.2 is very specific. The practitioner shall prepare a report without delay. It must include the woman's name and address, her age, a description of material taken from her for DNA profiling, details of any marks of injury on her person, her general mental condition, and any other relevant material particulars. The report must also state the precise reasons for each conclusion reached.
And confirmation of consent.
Yes, crucially, Section 184.5 requires the report to specifically record that the consent of the woman or person acting on her behalf was obtained. The exact time of the commencement and completion of the examination must also be noted.
Where does the report go?
The practitioner forwards the report to the investigating officer within 7 days, who then forwards it to the magistrate as part of the case documents under Section 193. This whole section standardizes the process, focusing on consent, forensic detail, and timely professional execution, vital for both justice and victim care.
For gathering other kinds of physical evidence, police often need to conduct searches. Section 185 covers search by police officer. This is about searching without a warrant from a magistrate, right?
Correct. This outlines the conditions under which an officer in charge of a police station or a police officer making an investigation can conduct a search without first getting a warrant.
What are those conditions?
The officer must have reasonable grounds for believing that something necessary for the purposes of an investigation into an offense they are authorized to investigate may be found in any place within the limits of the police station they are attached to, and that such a thing cannot, in their opinion, be otherwise obtained without undue delay.
So, reasonable belief plus urgency.
Essentially, yes. And there's a procedural safeguard. The officer must record in writing the grounds of their belief and specify in that record, as far as possible, the thing for which the search is to be made. This record must be kept in the case diary.
Do they have to conduct the search themselves?
Section 185(2) says the officer shall, if practicable, conduct the search in person.
And is there a requirement for recording the search itself?
Yes, another crucial modern requirement here. Section 185(2) also mandates that the search shall be recorded through audio-video electronic means, preferably by mobile phone.
Again, mandatory videography for transparency.
Exactly. If the officer can't conduct the search in person and there's no other competent person available at the time, they can, after recording their reasons in writing, require a subordinate officer to make the search. They have to give that subordinate officer a written order specifying the place and the thing to search for.
Do the general rules about searches apply?
Yes, Section 185(4) states that the general provisions of the code relating to searches, like those for search warrants, apply to a search made under this section as far as possible.
What about oversight? Do these warrantless searches get reported?
Yes, accountability is built in. Copies of any record made the grounds for belief. The reasons for deputing a subordinate must be sent forthwith to the nearest magistrate empowered to take cognizance of the offense within 48 hours. And the owner or occupier of the place searched gets a free copy of these records upon application.
So it balances the need for quick evidence collection with accountability through written records, videography, magistrate oversight, and transparency for the person whose property was searched.
That's the clear intention. The law also streamlines interjurisdictional searches in Section 186. An officer can require another station's officer to conduct a search, or in urgent cases where delay might cause evidence loss, an officer can search in another station's limits themselves, following the same procedures, recording grounds, videography, and immediately notifying the local station officer and the nearest magistrate.
Okay, investigations obviously take time, but individual liberty is also paramount. Section 187 deals with the procedure when investigation cannot be completed in 24 hours and how police can get authorization for extended custody. This seems like a really critical balance, doesn't it?
This section is absolutely critical, yes.
Yeah.
It governs the power of the police to detain an arrested person beyond the initial 24-hour limit, which is a general rule reference from Section 58, and outlines the crucial role of the magistrate in overseeing detention during investigation.
So what happens after 24 hours if the police aren't done investigating?
If the investigation cannot be completed within the 24-hour period, and the officer believes there are grounds that the accusation or information against the arrested person is well-founded, the officer, not below the rank of sub-inspector, shall forthwith transmit a copy of the entries in the case diary relating to the case to the nearest judicial magistrate.
And send the accused person too.
Yes. They must also forward the accused person to that magistrate. The magistrate can then, whether they have jurisdiction to try the case or not, authorize the detention of the accused in such custody as they think fit, either police custody or judicial custody.
For how long initially?
For a term not exceeding 15 days in total. The magistrate can authorize detention in police custody for parts of this initial 15-day period if satisfied there are adequate reasons, but police custody cannot exceed 15 days in the whole. After that, detention must be in judicial custody, i.e. in jail.
So the 15-day limit isn't the absolute maximum of detention during investigation.
No, that's just the initial period and the maximum for police custody. The magistrate can authorize further detention beyond 15 days in judicial custody if they're satisfied that adequate grounds exist for doing so.
But there's an overall limit, right?
Yeah.
To prevent indefinite detention.
Yes, and this is the crucial safeguard for liberty. Section 187(3) sets absolute maximum limits for total detention during the investigation period. Detention cannot exceed 90 days, where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years.
90 days for the most serious offenses.
Correct. And 60 days, where the investigation relates to any other offense.
60 days for everything else. What happens when that limit is reached?
This is fundamental. Upon the expiry of the said period of 90 days, or 60 days as the case may be, the accused person shall be released on bail if they are prepared to and do furnish bail. This is often referred to as default bail or statutory bail.
So release is mandatory if the investigation isn't complete and charge sheet filed by then.
It's a mandatory right to bail, provided the accused furnishes the required bail bond. It's a powerful check ensuring investigations are concluded within a reasonable time frame and preventing prolonged pretrial detention solely for investigation purposes.
How does the law ensure oversight during these custody extensions? Does the accused have to be present?
The accused must be produced in person before the magistrate for the first authorization of detention and for any subsequent authorization of detention in police custody.
Okay, always physically present for police custody requests.
Yes. However, for subsequent extensions of judicial custody, the production of the accused can be done either in person or through the medium of audio-video electronic means.
Using technology for judicial custody extension.
Yes. There are also specific protections. For a woman under 18 years of age, any detention shall be authorized to be in the custody of a remand home or recognized social institution, not regular police custody or jail.
A key protective measure.
Definitely. And the magistrate authorizing police custody shall record their reasons for doing so. Any magistrate granting detention, other than the Chief Judicial Magistrate, must forward a copy of their order with reasons to the CJM, ensuring higher judicial oversight.
Is there a mechanism to stop investigations that drag on too long in minor cases?
Yes. Section 1 Terry 7-9 deals with summons cases, less serious offenses. If the investigation in such a case isn't concluded within 6 months from the date of the accused's arrest, the magistrate shall make an order stopping further investigation unless the investigating officer satisfies the magistrate that for special reasons and in the interests of justice, the continuation of the investigation beyond 6 months is necessary. A sessions judge can potentially vacate such a stopping order.
So this whole section provides a comprehensive framework balancing investigative needs with robust individual liberty protections, judicial oversight, time limits, and bail provisions.
Exactly. It's one of the cornerstones ensuring procedural fairness during the crucial investigation phase.
Once investigations are conducted, there's a clear process for reporting the outcome and moving the case forward. How does the police hierarchy manage this internally, and what happens if the investigation reveals the evidence just isn't strong enough?
Well, Section 188 ensures internal accountability. Any subordinate police officer conducting an investigation must report the result to the officer in charge of the police station.
Okay, clear reporting lines. What if the result is not enough evidence?
That's covered by Section 189, release of accused when evidence deficient. If, upon investigation, it appears to the officer in charge that there is not sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to a magistrate.
They don't have a strong case.
Right. Then the officer shall release him on his executing a bond or bail bond, with or without sureties, as the officer directs. The condition is that the person must appear, if and when required, before a magistrate empowered to take cognizance of the offense.
So they're released, but might still have to appear later if needed.
Yes, but it prevents unnecessary judicial process and detention when the police's own investigation shows the evidence is weak. It reinforces the principle of innocent until proven guilty.
But if there is sufficient evidence or reasonable grounds, then the case goes to a magistrate for formal charges. That's Section 190. Cases to be sent to magistrate when evidence is sufficient. What does that involve?
If the investigation reveals sufficient evidence or reasonable grounds, the officer in charge shall forward the accused under custody to a magistrate empowered to take cognizance and either try the case or commit it for trial.
They send the person to court. What if it's a bailable offense?
If the offense is bailable and the accused is able and willing to give security, the proviso to Section 191 says the police officers shall take security from them for their appearance before the magistrate on a fixed day. The magistrate cannot refuse to take cognizance solely because the accused wasn't brought in custody.
What else goes to the magistrate?
When forwarding the accused, or taking security, the police shall send any weapon or article which it's necessary to produce before the magistrate. They also require the complainant, if any, and key witnesses, those acquainted with the facts, to execute a bond to appear before the magistrate and give evidence.
So ensuring witnesses show up too.
Yes. A copy of this bond is given to one of the executors, and the original is sent to the magistrate with the final police report, which we'll get to. This section outlines the formal handover of a case from police investigation to the judicial process when there's enough evidence, ensuring all relevant parties and evidence are presented to the court.
Is there any protection for complainants and witnesses being transported to court? Section 191 seems relevant. Complainant and witnesses not to be required to accompany police officer.
Yes. This protects their rights during this transition. Section 191 states clearly that no complainant or witness on his way to any court shall be required to accompany a police officer or shall be subjected to unnecessary restraint or inconvenience. They also cannot be required to give any security for their appearance other than their own bond.
So they shouldn't feel like they're in custody themselves.
Exactly. The exception is if they refuse to attend court or refuse to execute the required bond to appear in that case. The officer may forward them in custody to the magistrate, who might detain them until they execute the bond or the hearing is over. It balances the need for witnesses with their right to freedom from unnecessary police control.
Throughout the investigation, police are supposed to keep records. Section 192 talks about the diary of proceedings and investigation.
Yeah.
The case diary. What's its purpose?
The case diary is a crucial internal record. Section 192 mandates that every investigating police officer shall day by day enter their proceedings in a diary.
What kind of details go in?
It should detail the time the information reached them, the time they began and closed the investigation, the places they visited, and importantly, a statement of the circumstances ascertained through their investigation.
Do witness statements go in there?
Yes, Section 192 clarifies that statements of witnesses recorded under Section 180 shall be inserted in the case diary. The diary itself should be a bound volume and properly paginated.
Can the courts see this diary?
Yes, Section 192.4 allows any criminal court to send for the police diaries of a case under inquiry or trial before it, and the court may use such diaries not as evidence in the case, but to aid it in such inquiry or trial.
Aid, not evidence. What does that mean?
It means the court can look at the diary to understand the flow of the investigation, maybe check dates or sequences of events, or get leads for questioning, but the contents of the diary itself cannot be used as substantive proof of the facts mentioned within it against the accused.
Can the accused see the diary?
Generally, no. Section 195 states that neither the accused nor their agents are entitled to call for or see the diaries just because the court referred to them. However, if the police officer uses the diary to refresh their memory while testifying, or if the court uses it to contradict the police officer, then relevant provisions of the Evidence Act regarding cross-examination on previous written statements would apply.
So it highlights the dual nature of the diary. A vital internal police record and a tool for judicial aid, but with strict rules preventing its direct use as evidence against the accused, protecting fairness.
Exactly. It maintains that crucial distinction.
Finally, we reach the end of the investigation. Section 193 covers the report of police officer on completion of investigation, often called the charge sheet or final report. What does this involve?
This section outlines the culmination of the police investigation. First, Section 193 reiterates that every investigation shall be completed without unnecessary delay.
Is there a specific time frame for completion?
For certain serious offenses, yes. Section 193 mandates that investigation in relation to specific sexual offenses, listed by section number, shall be completed within 2 months from the date on which the information was recorded by the officer in charge.
2 months for those specific serious cases. What happens when any investigation is complete?
As soon as it's completed, the officer in charge shall forward a report to the magistrate, who is empowered to take cognizance of the offense based on a police report. This report can be sent electronically as well.
What needs to be in this final report?
Section 193 lists the required contents. It must state the names of the parties, the nature of the information, the names of persons acquainted with the case, whether any offense appears to have been committed, and if so, by whom, whether the accused has been arrested, whether they've been released on bond, whether they're being forwarded in custody.
And specific details for certain cases.
Yes. It must state whether the medical examination report of a woman victim, in relevant cases, has been attached. And reflecting modern investigations, it needs to include the sequence of custody of electronic devices seized during the investigation, a crucial detail for ensuring the integrity of digital evidence.
So a comprehensive summary. What about keeping the victim or informant updated?
That's also mandated now. Section 193 requires the police to inform the progress of the investigation to the informant or victim within 90 days, and this can be done electronically. Section 193 also requires communicating the action taken, i.e. the outcome of the investigation, to the first informant.
So improve transparency for those involved.
Definitely. If a superior officer was overseeing the investigation, the report might be submitted through them, and they can add instructions or direct further investigation if needed. The report should be accompanied by all the documents the prosecution relies on that weren't sent earlier, and the statements of all prosecution witnesses recorded under Section 180.
What if some information in a witness statement isn't relevant or sensitive?
Section 193 allows the police officer to indicate parts of a statement they consider irrelevant or believe would be against public interest to disclose, provided it's not essential for justice. They can request the magistrate exclude these parts from the copies given to the accused, stating their reasons.
And the accused gets copies of everything else.
Yes, Section 193 requires the police to submit copies of the report and all accompanying documents properly indexed for the accused, as required by Section 230, which deals with supplying copies. Electronic supply is considered valid service.
Can the police investigate more even after filing this report?
Yes, absolutely. Section 193 explicitly states that nothing precludes further investigation after the initial report is submitted. If the police obtain further evidence, oral or documentary, they shall forward a further report or reports regarding such evidence to the magistrate.
What if the trial has already started?
Further investigation during trial requires the permission of the court conducting the trial. If permitted, it must be completed within 90 days, though the court can extend this period.
So the investigation isn't necessarily closed forever once the report is filed?
Not at all. This section emphasizes speed and thoroughness in the initial investigation, victim updates, modern evidence handling, but also maintains the possibility of revisiting a case with new information, reflecting the ongoing pursuit of truth, even during trial.
Finally, let's briefly look at how the police and magistrates handle investigations into deaths that aren't immediately clear as criminal offenses, but are suspicious or unnatural. Section 194 covers police to inquire and report on suicide, etc.
This section outlines the police's initial response in these specific circumstances. It's triggered when an officer in charge, or another officer specially empowered by the state government, receives information that a person has committed suicide or has been killed by another person or by an animal or by machinery or in an accident or has died under circumstances raising a reasonable suspicion that some other person has committed an offense.
So, any unnatural or suspicious death, what's the first step?
The officer must immediately give intimation to the nearest executive magistrate who is empowered to hold inquests.
Notify the magistrate right away. Then what?
Unless directed otherwise by a relevant magistrate, the police officer shall proceed to the place where the body of the deceased person is. There, in the presence of 2 or more respectable inhabitants of the neighborhood, they must make an investigation and draw up a report.
What's in that report?
It should detail the apparent cause of death, describe any wounds, fractures, bruises, or other marks of injury found on the body, and state how such marks appear to have been inflicted. The report is signed by the police officer and the other persons concurring, and it's forwarded to the district magistrate or the subdivisional magistrate within 24 hours.
Are there specific cases where the body must be sent for a formal medical examination? This seems like a critical safeguard, perhaps for certain vulnerable groups.
Yes, Section 194.4.3 mandates forwarding the body for examination by the nearest civil surgeon or other qualified medical person in several key situations.
What situations?
These include if the case involves the suicide by a woman within 7 years of her marriage, or the death of a woman within 7 years of her marriage in circumstances raising reasonable suspicion that someone else committed an offense, or the death of a woman within 7 years of marriage and a relative requests an examination, or if there is any doubt regarding the cause of death, or if the police officer considers it expedient for any other reason.
So a strong focus on deaths of recently married women.
Yes, this reflects a specific legal concern about dowry deaths or other foul play in such circumstances, ensuring thorough medical scrutiny when these situations arise. Police also retain the power under Section 195 to summon witnesses for these death inquiries, with the same protections for vulnerable individuals regarding place of attendance, as we discussed for regular investigations under Section 179.
Finally, we have Section 196, Inquiry by Magistrate into Cause of Death. This sounds like the judiciary's direct involvement in certain death investigations, going beyond the initial police inquiry.
This is a particularly crucial provision for ensuring independent oversight and accountability in sensitive death cases. Section 196.1 mandates that for those cases involving the death of a woman within 7 years of marriage, suicide or suspicious circumstances, the nearest magistrate empowered to hold inquests shall hold an inquiry into the cause of death. This is in addition to, or instead of, the police investigation under Section 194.
So a mandatory magistrate inquiry in those specific cases.
Yes. In other cases, covered by Section 194.1, other suicides, accidents, suspicious deaths, any empowered magistrate may hold such an inquiry if they choose. When holding such an inquiry, the magistrate has all the powers they would have when conducting an inquiry into an offense, including recording evidence and even, under Section 196, causing a dead body to be disinterred and examined to discover the cause of death. Where practicable, relatives must be informed and allowed to be present during the inquiry.
And what about the most sensitive cases, like deaths that occur while someone is in police custody or allegations of rape in custody?
This is perhaps the most significant provision in this chapter for ensuring public trust and accountability. Section 19622 explicitly states that when any person dies or disappears, or rape is alleged to have been committed on any woman, while such person or woman is in the custody of the police or in any other custody authorized by the magistrate or the court, a magistrate shall hold an inquiry in addition to any investigation held by the police.
So a mandatory judicial inquiry for any custodial death, disappearance, or rape allegation.
Absolutely. This is a fundamental check on state power, ensuring independent judicial scrutiny when death or serious crime occurs under the direct care or control of the authorities. It aims to foster accountability and prevent potential abuses or cover-ups. In these custodial cases, and the mandatory inquiries for married women, the magistrate or investigating officer shall, within 24 hours of the death, forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical person, unless it's impossible for recorded reasons.
So these provisions together really underscore the judiciary's vital role in investigating critical or suspicious deaths, emphasizing independence, forensic evidence, and transparency, especially for deaths in custody or of recently married women.
Precisely. It adds a crucial layer of independent scrutiny to the most sensitive cases.
Wow, what a journey. I mean, from the fundamental obligation of maintenance, that safety net, to the intricate dance between civil force and armed forces and maintaining public order, dealing with everything from nuisances to property disputes.
A complex balance.
And then delving into the really detailed, often minute, procedures police and magistrates follow during investigations, reporting, evidence gathering, custody, videography. It's a lot.
It really is.
We've seen how the legal system tries to build this comprehensive framework for justice and stability, constantly adapting, it seems.
Indeed. What's truly fascinating here is the layered approach. You've witnessed how these procedures are designed on the one hand to provide recourse for those unable to maintain themselves.
Right, the maintenance part.
And on the other, to quickly address threats to public peace, and then to ensure police investigations are thorough, fair, and increasingly transparent, particularly with those provisions for vulnerable individuals and mandatory videography.
That transparency push is really noticeable.
It is, and it raises an important question, I think. In an era of such rapid technological advancement, social media, changing societal norms, how effectively can these detailed procedural laws, which strive for precision and fairness on paper, continue to adapt in practice? How do they keep pace while upholding both security and individual rights?
That's the ongoing challenge, isn't it?
It really is. It's a testament to the dynamic, living nature of justice itself, always trying to catch up, adapt, and remain relevant.
Absolutely. It's clear that these rules aren't just dry legal text. They're the blueprint, constantly being redrawn in some ways for how society handles some of its most sensitive and critical situations. It's that constant effort to balance order with liberty.
Well put.
We hope this deep dive has given you, our listeners, a newfound appreciation for the careful considerations and the robust mechanisms built into our legal system to protect, maintain, and investigate.
Hopefully some useful
Have
insights.
you ever really
Until
stopped
next
to
time,
wonder
keep
how the
digging,
law
keep
figures
questioning,
out
and keep
where a
being
crime
well
gets
informed.
tried? Especially, if it spills across different cities or even goes international,
Right.
or even just how a court actually starts a criminal case. That very first official step.
It seems simple on the surface, but yeah.
It's way more intricate and honestly pretty fascinating than you might think. And right now in India, that whole foundational system is getting a massive update.
A complete overhaul, really.
Welcome to The Deep Dive. This is the show where we dig into complex information and pull out the crucial insights just for you, the curious learner, who wants to be genuinely informed, but maybe without getting totally bogged down in dense legal texts.
We try to make it accessible.
We're your guides, ready to make even the toughest topics engaging, and maybe, just maybe, spark an aha moment or two.
Hopefully more than one.
Today, we're jumping into a deep dive covering two really foundational chapters of India's brand new criminal justice framework. We're looking at Chapter 14 and Chapter 15 of the Bhartiya Nagrik Suraksha Sanhita 2023. We'll just call it the BNSS from here on, okay?
Sounds good. BNSS it is.
So think of these chapters as the essential blueprints. Chapter 4 deals with the jurisdiction of criminal courts, basically, figuring out which court actually has the power to hear a specific case.
Where the trial happens.
Exactly. And Chapter 15, that's about cognizance of offenses and commencement of proceedings. Sounds technical, but it's about how a court formally kicks off a criminal proceeding. That official starting gun.
When the court officially takes notice, yeah.
Our mission today is to cut through the legalese, maybe highlight some surprising facts, and hopefully give you that moment where it all clicks. We want to reveal that intricate dance that happens right at the start between the police, the magistrates, the accused.
It's a critical stage.
We'll explore the why behind these rules, the real-world problems they're trying to solve, and importantly, the big modernizations the BNSS is bringing in.
Okay, let's unpack this. It's a huge shift in India's legal landscape.
What we're looking at here is effectively the bedrock of criminal procedure. It determines those very first steps, bringing someone to justice or, equally important, clearing their name if the case doesn't hold water.
Absolutely. You said it, the sections are fundamental. Without clear rules on jurisdiction, which court has the authority and how a court takes cognizance, that official judicial notice of an offense, well, the whole system would just seize up.
Grind to a halt.
Completely. We're going to see how the BNSS refines these essential mechanisms and, crucially, how it tries to adapt them to our rapidly changing world, especially, with technology just exploding.
Right, the digital age changes everything.
Right.
Okay, so let's start with the absolute basics, the foundation. When a crime happens, what's the #1 most fundamental rule for deciding where it gets tried? The default setting, if you like.
That brings us straight to Section 197. It's titled Ordinary Place of Inquiry and Trial. And that title says it all, really. It lays down the foundational principle, the default rule. A crime is typically inquired into and tried where it was actually committed.
The law of the land where the offense occurred.
Exactly. The section itself says, every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed.
Okay, ordinarily.
Yeah.
That word jumps out immediately. It suggests this is the general rule, but there are exceptions coming.
Precisely. That ordinarily is doing a lot of work there. It's critical because it signals, look, this is the default, the starting point, but hold on, things can get complicated. We'll see those complications, those exceptions, laid out in the sections that follow.
And every offense, so it applies across the board.
Across the board. All crimes under the BNSS or any other law. Consistency. And the last part, by a court within whose local jurisdiction it was committed, just hammers home that the court's geographical power needs to match the crime scene's location.
It feels very straightforward, almost common sense. Is there a deeper significance to starting with something so, well, basic?
Oh, absolutely. Its significance is in that clarity and convenience. It's usually the most practical place for gathering evidence, finding witnesses, even for the accused to attend court. It's also based on that universally accepted territorial principle. A state has authority over crimes within its borders.
Right.
But maybe most importantly, it gives us a solid foundation, a stable starting point, before we have to wrestle with the trickier scenarios where crimes don't fit neatly into one location.
So, a simple example. Someone steals a bike in, say, Prayagraj. The local magistrate or sessions court in Prayagraj handles it. Straightforward.
Exactly. The local police station registers the FIR, the investigation happens there, the trial happens there. Clean and simple. That's the ordinary situation.
But, like you said, life isn't always that neat. Crimes can be messy, geographically speaking. What happens when a crime spans locations? Or maybe it's just genuinely confusing where it actually happened. Let's get into navigating complex geographies. When the crime spans locations, how does the BNSS deal with these jurisdictional puzzles?
Okay, this is where Section 198, titled Place of Inquiry or Trial, becomes essential. This section lays out the crucial rules for those messy situations. Crimes where the location is ambiguous, uncertain, or stretches across multiple areas.
So it's designed to stop cases falling through the cracks.
Exactly. It's designed to prevent what lawyers call jurisdictional deadlocks. Situations where no court feels it can definitively claim authority and justice just evaporates because everyone's pointing fingers elsewhere.
That would be a disaster.
Yeah.
So what kind of situations does Section 198 cover?
Well, it covers a few key scenarios. First, uncertain location. Imagine a body is found floating in a river, and that river forms the boundary between District X and District Y. It's genuinely unclear which side the crime actually occurred on. In that case, Section 198 says a court in either District X or District Y can try the offense. The law doesn't want to get bogged down arguing about river currents.
Practicality first. What else?
Then you have offenses committed, partly in one area, partly in another. A classic example is, say, a criminal conspiracy hatched in Delhi.
Planning happens there.
Right. But the actual execution, maybe a fraudulent transaction, happens in Mumbai. Section 198 allows courts in either Delhi or Mumbai to handle the trial.
Makes sense.
It also covers situations involving several acts in different areas. Think about a kidnapping. The person might be abducted in State A, held captive in State B, and then a ransom call made from State C.
So multiple parts of the crime in different places.
Exactly. In that scenario, courts in any of those locations, A, B, or C, could try the case. And finally, it deals with continuing offenses, like wrongful confinement, where someone is illegally held and moved across several districts over time. Any court in any area where the offense continued can take jurisdiction.
So the overall theme is flexibility, giving the system the tools it needs to pursue justice, even when the where is complicated.
That's the core idea. It reflects the reality that crimes often ignore administrative boundaries. It gives the prosecution the necessary flexibility to choose a relevant court and ensures these complex cases don't just get lost in procedural arguments.
Building on that idea of complexity, what if the act happens in one place, but the main impact or consequence is felt somewhere else? That sounds like Section 199. Offense triable where act is done or consequence ensues.
Yes, Section 199 significantly broadens the jurisdictional net. It states that a crime can be tried not just where the physical act took place, but also where its consequences were felt. The key phrase is when an act is an offense by reason of anything which has been done and of a consequence which has ensued.
Okay.
In that situation, the trial can happen in the court where either the act was done or the consequence ensued.
So let's take an example. Mr. R in Lucknow sends a threatening email
Okay, act done in Lucknow.
to Mr. S in Kanpur. Mr. S reads it in Kanpur and feels genuinely threatened. The fear, the consequence, happens in Kanpur.
Perfect example. Under Section 199, courts in either Lucknow, where the act was done, or Kanpur, where the consequence ensued, could potentially try the case for criminal intimidation.
That seems quite victim-centric, potentially allowing victims to bring cases closer to where they suffered the harm.
It can be, yes. It extends jurisdiction beyond just the physical action to include the crime's impact. It's crucial for things like causing hurt, certain types of fraud, and as you said, intimidation. It acknowledges the full ripple effect of a crime.
And what about crimes that are linked? Like one crime is almost a setup for another, or part of a bigger plan. That sounds like Section 200. Place of trial where act is an offense by reason of relation to other offense?
Right. The core idea here is efficiency and seeing the whole picture. When one offense is intrinsically linked to another, maybe it facilitates it or is just part of the same criminal scheme, they can often be tried together in a single jurisdiction.
How does the law define that link?
It applies when an act is an offense by reason of its relation to any other act which is also an offense. If that connection exists, the first offense can be tried in a court where either of the offenses was committed.
Okay, so this would be crucial for things like conspiracy, like we mentioned, or maybe receiving stolen property.
Exactly. Those are prime examples. Abetment, too. Think about it. Mr. T commits a robbery in District A. Then Mr. U knowingly receives the stolen goods in District B. Mr. U's crime is directly related to Mr. T's robbery, right?
Clearly.
Under Section 200, a court in either District A, where the robbery happened, or District B, where the goods were received, can try Mr. U for receiving stolen property. And depending on other rules about joining charges, they might even be able to try Mr. T for the robbery in the same court.
So it avoids splitting related crimes across different courts, saves time, and gives the judge the full context.
Precisely. It prevents inefficient, piecemeal trials and allows for a holistic view of the entire criminal transaction. Much more efficient.
It makes sense.
Yeah.
The law also needs to be practical about certain types of crimes that just, by their nature, involve movement. That brings us to Section 201, place of trial in case of certain offenses. It seems to set specific, often multi-venue rules for particular crimes.
Yes, this section is very pragmatic. It acknowledges that for certain offenses, pinning down a single place of commission is just unrealistic or overly restrictive. So it provides specific, often broader jurisdictional options.
What kinds of crimes are we talking about here?
Well, think about crimes involving movement or dispersed elements. For thuggee, dacoity, robbery, kidnapping, and abduction, the trial can happen where the crime was committed or where the victim was moved, confined, or detained, or even where stolen property related to the crime was received or possessed.
Wow, that's quite a few options.
It is. For criminal misappropriation or breach of trust, it could be where the property was received or where the offense itself occurred, like converting the property. For theft, it's where the theft happened or where the stolen property was possessed. For cheating, it could be where the cheating occurred or where the property was delivered as a result. Even certain marriage-related offenses, like bigamy, have specific rules like where the second marriage took place or where the accused last lived with the first spouse.
So again, it's about practicality. If someone is kidnapped in District A, held in District B, and rescued in District C.
Then the trial could happen in District A, B, or C. It gives the prosecution practical options and can sometimes be more convenient for victims or witnesses who might be scattered across these locations. It recognizes the fluid nature of these specific crimes.
And now for a section that feels very 21st century. Section 202. Offenses committed by means of electronic communications, letters, etc. This must be the BNSS directly tackling cybercrime jurisdiction, right?
Absolutely. This is a hugely important modernization. Think about the nightmare scenario for traditional jurisdiction rules. Online fraud, cyberstalking, ransomware attacks. The perpetrator might be in City A, the victim in City B, the server hosting the malicious website in City C, maybe even overseas.
The old rules based purely on physical location just fall apart.
Completely. They were designed for a physical world. Section 202 directly confronts this challenge for crimes committed via electronic communication, but also includes older forms like letter, telegram, or post office.
So how does it expand the jurisdictional possibilities for these types of crimes?
It casts a much wider net. An offense committed through these means can be tried in a court where the communication was sent or originated, where it was received or accessed by the victim, or any part of the criminal act was carried out using that communication, or where any consequence of the crime ensued.
That already covers a lot more ground than just the physical location of the offender.
It does. And crucially, it adds elements specific to the digital world. Jurisdiction can potentially also lie where the server or network infrastructure used in the crime is located, or even where crucial digital evidence like hard drives, phones, logs is seized or found.
That is incredibly comprehensive. It basically says, if there's a significant digital footprint or impact related to the crime in our area, we might have jurisdiction.
That's the essence of it. It gives investigating agencies and prosecutors multiple potential venues, making it much harder for cybercriminals to exploit geographical loopholes within India. It explicitly recognizes and adapts the law to the realities of modern communication and digital crime.
So let's revisit that phishing example. Mr. W in Bengaluru emails Mr. X in Chennai. Mr. X clicks, money is transferred from his Mumbai bank account.
Under Section 202, jurisdiction could potentially lie in Bengaluru, where the email was sent, Chennai, where it was received, accessed, and caused initial harm, or Mumbai, where the financial consequence, the money transfer, occurred. It closes those jurisdictional gaps that cybercriminals previously exploited.
A necessary update, for sure. What about crimes that happen literally while people are moving, like on a train or a bus? Section 203. Offense committed on journey or voyage.
This section addresses that specific scenario. It provides rules for crimes committed while a person is traveling on a journey or voyage, where pinpointing the exact location during the journey might be impossible or impractical.
Right, you might know it happened between Station A and Station B, but not the precise spot.
Exactly. So the rule is the offense can be tried by a court through or into whose local jurisdiction that person or thing involved in the offense, or that carriage or boat or that aircraft passed in the course of that journey or voyage.
So back to the train example. Robbery on the Delhi-Mumbai train, somewhere between Kota and Vadodara.
The trial could happen in Delhi, start of journey, Mumbai, end of journey, Kota, Vadodara, or any other jurisdiction the train passed through during that trip.
Maximum flexibility for transit crimes.
Yes. It's purely about practicality and ensuring these crimes don't fall into a void because the exact spot on the map is uncertain.
Okay, let's connect back to something we touched on earlier. Trying multiple related offenses together. Section 204, place of trial for offenses triable together. How does this work jurisdictionally?
This section builds on the idea of judicial economy. If a person is accused of several offenses committed in different local areas, but these offenses are legally triable together under the rules in Chapter 8, which deals with joining multiple charges in one trial.
Okay, so the law specifically allows them to be tried together.
Yes, if that condition is met, then Section 204 says the person may be inquired into or tried by any court competent to inquire into or try any of the said offenses.
So if Mr. Y goes on a crime spree, committing related thefts in District A, then District B, then District C, and the law allows those thefts to be tried together,
then a single court in any of those three districts, A, B, or C, can try all the offenses together in one consolidated trial.
that must save a huge amount of time and resources.
Immense. It avoids fragmented trials. gives the court the full picture of the criminal activity, and simplifies the whole process for everyone involved, prosecution, defense, witnesses. It promotes efficiency and a holistic view of justice.
Now, we've covered the main rules, but what about resolving disputes or ambiguities? Let's look at resolving jurisdictional ambiguities and external powers. First, Section 205. Power to order cases to be tried in different sessions divisions. This sounds like a higher-level administrative power.
It is. This section gives the state government discretionary power to shift cases around, specifically between different sessions divisions within the state. They can order any case or class of cases committed for trial in any district to be tried in any sessions division.
Why would they do that? Overriding the normal rules.
Usually for two main reasons. Administrative efficiency may be balancing caseloads between busy and less busy divisions, or if a judge is unavailable, or, more significantly, for fair trial considerations.
It's like local prejudice.
Exactly. If there's strong local sentiment, potential security issues, or concerns about witness intimidation that might compromise a fair trial in the original district, the state government can move the trial elsewhere within the state.
Is this power unchecked?
No, there's a crucial safeguard. This power is not repugnant to any direction previously issued by the High Court or the Supreme Court. So, if a higher court has already made an order about where the trial should be, the state government can't contradict that. Judicial orders take precedence.
So it's executive power, but clearly subordinate to the judiciary.
Precisely. It allows administrative flexibility, but keeps it within the bounds set by the courts.
But what if there's just genuine doubt about which court has jurisdiction under all these rules we've discussed? A real head-scratcher.
That's where Section 206 comes in. High Court to decide, in case of doubt, district where inquiry or trial shall take place. This section designates the High Court as the ultimate arbiter.
The tiebreaker.
Essentially, yes. It states, where a doubt arises as to the court by which any offense should be inquired into or tried, the High Court may decide which specific court will handle it. And importantly, the High Court's decision on this matter shall be final.
So if our complex financial fraud case spanning districts X, Y, and Z leaves the lower courts genuinely confused,
An application can be made to the High Court for that state, and the High Court will definitively rule which district's court gets the case. It prevents procedural deadlocks and endless arguments about where to even start the trial. It provides finality.
Okay, one more practical point in this chapter. What if a magistrate gets information about a crime, but it happened entirely outside their geographical area? Can they do anything at all? Section 207, power to issue summons or warrant for offense committed beyond local jurisdiction.
Yes, they can take initial steps. This section is about facilitating the very beginning of the process without unnecessary delay. It allows first-class magistrate, if they are satisfied that an offense has been committed, even though it's beyond the local limits of his jurisdiction, to still issue an initial summons or arrest warrant.
So they can kickstart the process even if they won't handle the full case.
Exactly. But if an arrest is made based on that warrant, the section mandates that the arrested person shall forward to the magistrate who does have the proper territorial jurisdiction over the crime scene. It's a handover mechanism.
So our magistrate in District A gets a complaint about a fraud wholly in District B. They can issue the warrant, get the person arrested, but then that person is sent to District B for the actual case.
Correct. It bridges that initial gap between receiving information and getting the case to the right court, preventing the accused from potentially disappearing while paperwork shuffles between districts.
And finally, the big one. Crimes beyond India's borders, extraterritorial jurisdiction. This is handled by Section 208, offense committed outside India. How can Indian courts try crimes that didn't even happen in India?
This is a really complex but important area of law dealing with extraterritorial jurisdiction. Section 208 lays out the grounds. It applies to offenses committed outside India under specific circumstances.
What are those circumstances?
Primarily two. First, if the offense is committed by a citizen of India, regardless of where they are in the world, this is the nationality principle. Indian law follows its citizens. Second, if the offense is committed by any person, even a non-citizen, on an Indian-registered ship or aircraft. This is the flag principle. The ship or aircraft is considered an extension of Indian territory.
Okay, so Indian law can reach its citizens abroad and anyone on its floating or flying territory, but is it automatic?
No, and this is absolutely critical. There's a mandatory requirement, except with the previous sanction of the central government. Without that explicit permission from the central government, an Indian court cannot take cognizance of such an offense.
Why is that government sanction needed?
It's a vital safeguard. Prosecuting someone for something they did in another country has major implications for international relations and diplomacy. The sanction ensures these prosecutions are pursued judiciously, considering potential conflicts of jurisdiction with the country where the crime occurred. It prevents India from, unilaterally stepping on another country's toes without careful consideration at the highest level. It often involves getting certificates or information from diplomatic channels.
So if an Indian citizen commits a serious crime, like, say, terrorism funding while living in country X and then returns to India,
Indian courts can potentially try them under Section 208, but only if the central government grants sanction. It ensures these serious overseas crimes don't go unpunished just because the person came back, but does so in a diplomatically sensitive way. Similarly, an assault on an Indian ship in international waters could be tried in India, regardless of the crew's nationality, but again, only with that central government sanction.
Okay, that wraps up jurisdiction. Now we move into Chapter 55, which focuses on how the court machinery actually starts rolling cognizance and commencement of proceedings. And interestingly, we start right back with the international angle. Handling evidence from beyond borders with Section 209, receipt of evidence relating to offenses committed outside India.
Yes, Section 209 is the practical follow-up to Section 208. If you're going to try someone in India for a crime committed abroad, how do you get the evidence from that other country into the Indian courtroom? Section 209 provides the mechanism.
How does it work?
It applies specifically to those extraterritorial offenses under Section 208, and only if the central government has directed it. If that direction is given, then evidence like copies of depositions made or exhibits produced from the foreign country can be used.
Copies, not original.
Copies, yes. And significantly, they can be in physical form or in electronic form. This evidence needs to come through official channels, typically certified by a foreign judicial officer or an Indian diplomatic or consular representative in that country.
And the key point.
The key point is the last phrase. Such copies shall be received as evidence. It makes these properly certified copies mandatorily admissible in the Indian trial.
That must streamline things massively. No need to fly witnesses halfway across the world for every trial.
Exactly. It's crucial for making transnational justice actually workable. Imagine the logistical nightmare otherwise. It avoids that, while the requirement for official certification ensures authenticity. And explicitly allowing electronic form is a huge nod to modern investigations. Think digital bank records, email trails, server logs from another country.
So if an Indian citizen is being tried in India for cyber fraud, they committed targeting someone in the U.S.
With the central government's direction, properly certified electronic copies of, say, U.S. bank transaction records, or a sworn statement from a U.S. victim taken before a local judge with Indian consular assistance must be admitted as evidence by the Indian court under this section. It's a vital tool for global crime fighting.
Okay, let's get to the absolute heart of this chapter, the formal beginning. When a court takes notice of a crime, this is Section 210, cognizance of offenses by magistrate. Let's break down cognizance again. What does it really mean for a magistrate to take cognizance?
Right, cognizance. In simple terms, it's the moment a magistrate applies their judicial mind to the facts presented about an alleged crime and decides, yes, there seems to be enough here to formally initiate judicial proceedings. It's the trigger point where a case officially enters the court system.
So it's not about deciding guilt or innocence at this stage.
Yeah, not at all. It's about deciding if there's a prima facie case enough on the face of it to warrant moving forward with a formal inquiry or trial. It's the judicial gatekeeping function. Generally, judicial magistrates first class, JMSCs, have this power inherently, while judicial magistrates second class, JMSCs, usually need specific empowerment from the Chief Judicial Magistrate, CJM.
And how does information about a potential crime actually reach the magistrate for them to consider taking cognizance? What are the routes?
Section 210 lays out three main ways or modes for taking cognizance. First, A, upon receiving a complaint of facts. This refers to private complaints filed directly with the magistrate, usually by the victim or someone authorized. This route bypasses the police initial investigation stage.
Okay, the direct-to-court route.
Second, and most common, B, upon a police report. This is the report filed by the police after they've conducted an investigation under Chapter 13, typically a charge sheet if they found evidence, or a closure report if they didn't. And importantly, the BNSS adds any mode, including electronic mode, explicitly recognizing digital filing of these reports.
Right, the police investigation route, now digitized.
And third, C, upon information received from any person other than a police officer or upon his own knowledge. This is a kind of catch-all. It could be information from a non-police source, like a news report the magistrate reads, a credible tip-off from a member of the public, or even in rare cases, if the magistrate personally witnesses an offense being committed.
So the magistrate isn't just passively receiving police files. They can act on complaints, police reports, or even other information, applying their own judgment.
Absolutely. Judicial independence is key here. They aren't just rubber stamping. The different modes ensure multiple access points to justice. But that third mode, acting on own knowledge or non-police info, is quite powerful and sensitive.
Which leads directly to a safeguard.
Exactly. It leads us straight to Section 211, transfer on application of accused. This is a crucial check and balance.
How does Section 211 work?
It's a specific protection for the accused that applies only when a magistrate has taken cognizance under that third mode, Section 210(1)(c), based on information from someone other than the police or their own knowledge.
Okay.
In that specific situation, the magistrate has a mandatory duty. Before any evidence is taken, they must inform the accused person that he is entitled to have the case tried by another magistrate or committed for trial, if applicable.
So the accused gets a choice to move the case.
Yes, and if the accused objects to being tried by the magistrate who took cognizance based on their own knowledge or private information and applies for a transfer, the magistrate shall transfer the case. No discretion there.
Why is this safeguard so important?
It's all about perceived bias. If a magistrate acts based on their own personal knowledge or information they received outside official channels, there could be a reasonable apprehension that they've already formed an opinion. This section ensures fairness and impartiality, or at least the appearance of it, by giving the accused the right to have a different, completely detached magistrate hear the case. It prevents any suggestion that the magistrate is acting as both witness and judge.
So if a magistrate sees someone dumping trash illegally and takes cognizance based on that,
They must tell the accused, look, I saw this myself and took cognizance. You have the right to have this case heard by another judge. If the accused says, yes, please transfer it, the magistrate has to oblige. It protects the integrity of the process.
Okay, now shifting gears slightly within the court system. Section 212, making over of cases to magistrates. This sounds like internal management.
It is, primarily. This section deals with caseload distribution. It empowers the Chief Judicial Magistrate, CJM, who acts as the administrative head for the other judicial magistrates in the district to assign or transfer cases.
Which cases can they assign?
A CJM can make over cases that they themselves took cognizance of, or perhaps cases that were transferred to them, maybe under Section 211, for example. They can assign these cases for inquiry or trial to any competent magistrate subordinate to him.
So it's about workload management.
Yeah.
Preventing one judge from being swamped.
Exactly. The CJM ensures the work is distributed efficiently among the available magistrates. It helps ensure cases are handled relatively quickly and allows, implicitly, for cases to be assigned based on a magistrate's experience level or specialization, if any. Purely administrative, but essential for keeping the courts running smoothly.
So a CJM gets a batch of 50 new police charge sheets. They don't have to handle all 50. They can allocate them to the 5 JMSCs working under them.
Precisely. Efficient allocation of judicial resources.
Now, what about the more serious crimes? We know they often end up in the court of session. How does that process start from a cognizance perspective? Section 213. Cognizance of offenses by court of session.
This section establishes a really important structural principle. Generally speaking, a court of session, the higher court that tries serious offenses like murder, rape, etc., does not take cognizance directly. It doesn't usually act as a court of first instance for taking notice of a crime.
So how do cases get there?
The rule is, no court of session shall take cognizance of any offense as a court of original jurisdiction unless the case has been committed to it by a magistrate. The case has to start with a magistrate taking cognizance, going through preliminary steps, and then being formally sent up or committed to the Sessions Court for trial.
So the magistrate acts as a gatekeeper or a conduit for serious cases heading to the Sessions Court.
Exactly. It establishes a two-tier system, particularly for cases arising from police reports. Magistrates handle the initial cognizance and preliminary procedures, essentially filtering the cases, before the more serious ones are passed up for full trial in the Sessions Court, which has the power to impose heavier sentences. There are a few specific exceptions where a Sessions Court can take direct cognizance of certain contempt proceedings, maybe some offenses under special laws, but the general rule is no direct cognizance, only via committal from a magistrate.
So for a typical murder case, based on a police charge sheet,
Yeah.
magistrate takes cognizance, does preliminary steps, then commits to sessions for trial.
That's the standard pathway.
And within the Sessions Court itself, how is the workload handled? There's often a principal sessions judge and then others. Section 214, additional sessions judges to try cases made over to them.
Right. Most districts have a principal sessions judge, but also additional sessions judges, ASJs, and sometimes assistant sessions judges to help manage the caseload of serious trials. Section 214 clarifies their role. It says an additional or assistant sessions judge shall try such cases as the sessions judge may make over to him for trial or as the High Court may direct.
So the principal sessions judge can delegate cases downwards.
Yes. They can assign cases from their docket to the additional or assistant sessions judges. And crucially, those judges then have the same powers to try the case as the principal sessions judge, though assistant sessions judges have limitations on the sentences they can impose. This delegation is absolutely essential for handling the high volume of serious criminal trials in busy districts. It allows multiple trials to run concurrently.
Makes sense for efficiency. Now back to the magistrates for a moment. What if a case lands on their desk, but they realize they simply aren't the right magistrate for it, wrong jurisdiction, or maybe not empowered for that type of offense? Section 215, procedure where magistrate is not competent to take cognizance.
This section ensures that a case doesn't just get lost because it was initially filed in the wrong place or before the wrong level of magistrate. If a magistrate receives a complaint or a police report but realizes they are not competent to take cognizance of that specific offense.
They don't just dismiss it.
No, they shouldn't. Their duty is to redirect it properly. If it's a written complaint, they should return it for presentation to the proper court with an endorsement explaining why they lack competence. If it's a police report or other information, they should forward it to a magistrate having jurisdiction.
So it's about ensuring the case gets to the right door, eventually.
Exactly. Justice over technicality. It facilitates the smooth flow of cases to the court that actually has the power to hear them, preventing delays and ensuring valid cases aren't thrown out due to initial procedural mistakes.
Okay, let's talk about time limits. Does the law put a clock on prosecuting certain crimes? Section 216, limitation on prosecution.
Yes, it absolutely does. Section 216 introduces the concept of limitation periods for taking cognizance of certain, generally less serious offenses. It's a crucial principle balancing the need for prosecution with fairness to the accused and the idea that legal proceedings shouldn't hang over someone's head indefinitely for minor issues.
What's the basic rule?
The section essentially says no court shall take cognizance after the expiry of the period of limitation. It imposes a time bar.
And what are those time limits, typically?
They usually depend on the maximum punishment for the offense. For offenses punishable only with a fine, the limitation period is typically 6 months. For offenses punishable with imprisonment up to 1 year, the limit is 1 year. And for offenses punishable with imprisonment exceeding 1 year but not exceeding 3 years, the limit is usually 3 years.
What about more serious crimes? Is there a time limit for murder, for instance?
No. And this is a critical exception. There is no period of limitation for offenses punishable with imprisonment exceeding 3 years, or with life imprisonment, or the death penalty. For these grave offenses, the pursuit of justice isn't time-barred.
So the clock only runs for relatively minor offenses.
Generally, yes. The idea is to ensure speedy prosecution for smaller matters, prevent the state from holding the threat of prosecution over someone for years for a minor infraction, and also ensure that evidence is still reasonably fresh. There are also provisions allowing courts to extend the limitation period in certain circumstances, like if the accused was deliberately avoiding arrest, or if the offense couldn't reasonably have been discovered earlier.
So a minor traffic violation needs to be prosecuted within 6 months. But a murder case could theoretically be brought decades later if new evidence emerges.
That's the essence of it. Limitation applies to less serious crimes, not the most heinous ones.
Okay, so assuming cognizance is taken within the time limit, if any, and the magistrate is satisfied there's a case, what is the absolute first formal step involving the accused? Section 217, commencement of proceedings.
This section marks the official start line of the formal judicial process involving the accused. It defines when proceedings commence. This happens after the magistrate has taken cognizance and has formed the opinion that there are sufficient grounds for proceeding, which is a slightly higher threshold than just taking cognizance.
And how do they commence proceedings?
By issuing process to secure the accused's attendance before the court. This means issuing either a summons or a warrant.
Summons versus warrant, what's the difference in practice?
A summons is basically an official order to appear in court on a specific date. It's used for less serious offenses, typically called summons cases. For these, the magistrate shall issue summons. A warrant is more serious. It's an order, usually to the police, to arrest the accused and bring them before the court. This is typically used for more serious offenses called warrant cases. For these, the magistrate may issue a warrant, or, if he thinks fit, a summons. They have discretion in warrant cases to use the less coercive summons if the situation warrants it.
So the type of process depends on the seriousness of the alleged crime.
Generally, yes. Section 217 also adds a practical point. In summons cases, the magistrate can sometimes dispense with the accused's personal attendance and allow them to appear through their lawyer, especially for minor matters. But the core point is, proceedings commence with the issuance of that summons or warrant, formally bringing the accused into the judicial picture.
Okay, that clarifies the start. Let's delve deeper into the magistrate's role in filtering complaints and police reports. We know they take cognizance, but what's the specific procedure when they get a private complaint? Section 218. Procedure to be adopted by magistrate on receipt of complaint.
Right. Section 218 focuses specifically on complaints filed directly by individuals, not police reports. When a magistrate receives such a complaint, the first mandatory step is crucial. The magistrate shall at once examine upon oath the complainant and the witnesses present, if any.
Examine them under oath right at the start.
Yes. This immediate examination is vital. The magistrate needs to hear directly from the complainant, assess their demeanor, understand the allegations, and record the substance of this examination in writing, which is then signed. It's an initial check on the seriousness and potential veracity of the complaint.
Are there exceptions to this mandatory examination?
Yes, a couple of practical ones. It's not required if the complaint is filed by a public servant acting in their official capacity or by a court. Also, if the magistrate, after examining the complainant, decides to make over the case to another magistrate under Section 212, the second magistrate doesn't need to re-examine them.
What happens after this initial examination? Does the magistrate issue process immediately?
Not necessarily. Section 218 also mentions the magistrate's power, which is detailed more in Section 225, to postpone issuing process if they have doubts or want more information. They can then either inquire into the case themselves or direct an investigation by police or someone else to verify the facts before deciding whether to summon the accused.
So another filter.
Exactly. And if, after the examination and any subsequent inquiry, the magistrate finds no sufficient grounds for proceeding, they must dismiss the complaint, recording their reasons, as per Section 226. Only if they are satisfied that there are sufficient grounds will they then proceed to issue the summons or warrant under Section 217.
So for private complaints, there's this multi-stage scrutiny. Initial sworn examination, potential postponement for inquiry investigation, and then a final decision on whether to issue process or dismiss.
That's a good summary. It's designed to weed out frivolous or unfounded private complaints early on.
Now, what about the more common route when the police file the report after investigation? Section 219. Procedure to be adopted by magistrate on receipt of police report. How does the magistrate handle these?
When a magistrate receives a police report under Section 193, which is the final report, either a charge sheet or a closure report, Section 219 outlines their options. Crucially, the magistrate is not bound by the police's conclusion. They must apply their own judicial mind to the report and the accompanying materials.
So what can they do?
They have several key options exercising their judicial discretion. 1, they can accept the police report if it's a charge sheet finding evidence and take cognizance, then proceed to issue process, a summons warrant, to the accused under Section 217. 2, they can take cognizance and proceed directly to inquiry or trial, depending on the nature of the case. 3, even if the police filed a charge sheet, the magistrate might feel the investigation was inadequate. In that case, they can take cognizance but direct the police to conduct further investigation under Section 1939 to gather more evidence or explore specific angles. 4, if the police filed a closure report, saying no case is made out, the magistrate can review the materials and agree with the police, refuse to take cognizance, and dismiss the case, recording reasons. 5, conversely, even if the police filed a closure report, the magistrate might disagree with the police conclusion after reviewing the evidence. They could then reject the closure report, take cognizance of the offense, and issue process to the accused. 6, they might also direct the police to take some other specific action consistent with the BNSS procedures.
Wow, so the magistrate has significant power to override or redirect the police investigation's outcome based on their own assessment of the evidence.
Absolutely. It underscores the principle of judicial oversight over the police investigation process. The magistrate acts as a critical check, ensuring that decisions to prosecute or close a case are judicially sound, not just based on the police's opinion. Transparency is also key. Decisions to refuse cognizance or dismiss usually require recorded reasons.
Okay, now let's look at some specific areas where the law imposes extra hurdles before a court can even take cognizance. Safeguards and restrictions for sensitive offenses. First up, Section 220. Prosecution for offenses against public justice, etc. What's this about?
Section 220 places a significant jurisdictional bar on courts taking cognizance of certain specific offenses, mainly those relating to contempt of the lawful authority of public servants, like disobeying an order, giving false information to them, and offenses against public justice committed in or in relation to court proceedings, like giving false evidence or fabricating evidence for court.
So you can't just file a private complaint for perjury, for example.
Exactly. The rule is strict. No court shall take cognizance of these specified offenses, except on a complaint in writing by either the public servant concerned or their official superior for offenses committed against their authority in the line of duty, or the court concerned or an officer authorized by it for offenses committed in or in relation to proceedings before that court.
Why this restriction? Why can't anyone complain if they see false evidence being given?
It serves two main purposes. First, it protects public servants from vexatious litigation and harassment while they're just doing their jobs. Imagine if anyone could drag an official to court for perceived disobedience. Second, and perhaps more importantly, it protects the integrity and administration of justice itself. Offenses like perjury directly attack the court's process. The law reserves the right to the court itself, or the affected public servant, to decide whether initiating a prosecution for such an offense is necessary and appropriate. It prevents parallel or collateral litigation where parties might try to use accusations of false evidence to derail the main case.
So it acts as a strong filter, ensuring only the directly affected authority, the public servant, or the court can initiate these specific types of prosecutions.
Precisely. Precedent under the old law, like M.S. Alawat, confirms this bar is absolute. If the procedure isn't followed, the entire prosecution is invalid. So if a lawyer thinks a witness lied on the stand, the lawyer can't file a complaint. They need to bring it to the attention of the court where the testimony was given, and that court decides whether to file a complaint for perjury.
Very clear. Now, another sensitive area. Section 221, cognizance of offense in marital relationships. This sounds like it deals with offenses occurring within a marriage.
Yes, Section 221 provides a very specific restriction, focusing primarily on the offense defined in Section 67 of the Bhartiya Nagrik Suraksha Sanhita, BNSS 2023. This section deals with a man engaging in sexual intercourse with his own wife during a period of judicial separation without her consent.
Okay, a very specific scenario. What's the restriction on taking cognizance?
The section states, no court shall take cognizance of this specific offense, BNS 67, where the parties are married, except upon prima facie satisfaction of the facts, upon a complaint having been filed or made by the wife against the husband.
So, two key conditions here. Only the wife can file the complaint, and the magistrate needs to be satisfied prima facie with the facts before even taking cognizance.
Exactly. No third party, not a neighbor, not a relative, not even the police acting on their own can initiate this case. The right to complain rests solely with the wife. And even when she complains, the magistrate has an initial gatekeeping role to be satisfied on the face of it that the alleged facts constitute the offense before formally taking cognizance.
What's the thinking behind this specific restriction?
It reflects the extremely sensitive nature of offenses within a marital relationship, even during separation. The law prioritizes the wife's autonomy and agency, her decision whether or not to pursue legal action in such a deeply personal matter. It aims to prevent misuse of the law for harassment or coercion by third parties and avoids external interference in the marital sphere unless the aggrieved wife herself chooses to involve the legal system. It aligns with broader legal principles emphasizing the dignity and agency of women within marriage, as seen in judgments like Joseph Schein.
So even if someone else reports such an incident, the court simply cannot act unless the wife herself files a formal complaint and the magistrate finds initial merit in it.
That's the essence of Section 221, a very specific safeguard for a very specific and sensitive offense.
Moving on to Section 222, prosecution for defamation. Reputation is personal, so it makes sense there might be special rules here too.
Yes, defamation law has always had unique procedural aspects because it deals with harm to reputation. Section 222 lays these out. The fundamental rule in subsection 1 is, no court shall take cognizance except upon a complaint made by some person aggrieved by the offense.
Only the person whose reputation was harmed can complain.
That's the general rule. You can't file a defamation case on behalf of your friend just because you feel they were wronged. The person aggrieved, the one defamed, must be the complainant. This prevents busybodies or people with ulterior motives from clogging the courts with defamation suits.
What about people who might find it difficult to complain themselves, like minors or someone very ill?
There's a proviso for that. It allows a proxy complainant, like a family member or another representative, to file the complaint with the court's permission, leave of the court. If the aggrieved person is a minor, is mentally disabled, is sick or infirm, or is a woman who, according to local customs and manners, ought not to be compelled to appear in public. It ensures access to justice for vulnerable individuals.
Okay, that covers private defamation. What if the defamation is against a high-ranking public figure like a minister or the president regarding their official duties? Does that follow the same aggrieved person rule?
Here, Section 222 provides a special alternative procedure. For defamation against the president, vice president, governors, union or state ministers, or other public servants concerning their conduct in the discharge of public functions, a court of session, note, not a magistrate initially, may take cognizance upon a complaint in writing made by the public prosecutor.
So the state itself, through the public prosecutor, can initiate the case in the sessions court. Why this special track?
The rationale is that defamation of high officials concerning their official duties can undermine public trust and the functioning of the state itself. This procedure allows for a potentially quicker and more direct route to trial in a higher court. However, there are strict controls.
Such as?
Two key ones. First, the public prosecutor cannot file such a complaint without the previous sanction of the relevant government, state or central. This acts as a filter against frivolous or politically motivated prosecutions. Second, there's a strict time limit. The public prosecutor's complaint must be filed within 6 months from the date of the offense.
So if a newspaper publishes something defamatory about a chief minister's official actions,
The public prosecutor, with state government sanction, could file a complaint directly in the Sessions Court within 6 months. However, subsection 6 clarifies that this special procedure doesn't take away the chief minister's personal right to file their own private defamation complaint before a magistrate under the general rule if they choose to do so. They have both options.
so the aggrieved person rule is central, with specific exceptions for vulnerable people and a parallel track for high officials acting in their public capacity, subject to safeguards.
Exactly. And the constitutionality of this framework, including the aggrieved person rule and the special procedure for public servants, was upheld by the Supreme Court in the Subramanian Swamy case.
Okay, now we arrive at what you called perhaps the most pivotal modernization in this chapter, the accused's new precognizance right and judicial scrutiny. This revolves around Section 223, the examination of complainant and witnesses. You said this introduces a revolutionary change.
It really does. Section 223 starts similarly to the old law. It reiterates the magistrate's duty to examine upon oath the complainant and the witnesses present when dealing with a private complaint. That initial verification step remains. But then comes the game changer, a brand new proviso.
And what does this proviso say?
It says, provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard.
Let me make sure I heard that right. Before the magistrate even takes cognizance of a private complaint, they have to give the person being accused a chance to be heard.
That's exactly what it says. This is a fundamental departure from the previous Code of Criminal Procedure, CRPC. Under the CRPC, the accused typically had no right to participate or be heard before the magistrate decided to take cognizance and issue process, like a summons. Their involvement usually started only after that decision was made.
Wow. So this means the person named in the complaint gets to come forward, maybe present their side of the story, show evidence, before the court even formally accepts the case.
Precisely. Think about the implications. This directly tackles the long-standing issue of potentially frivolous, vexatious, or downright false private complaints being filed simply to harass someone. Now, the person being accused has a chance, right at the threshold, to demonstrate to the magistrate why the complaint lacks merit, perhaps by showing documents, pointing out suppressed facts, or establishing an alibi, before the magistrate takes that formal step of cognizance and issues a summons, which itself carries a stigma.
This seems like a massive enhancement of due process at the very beginning. It empowers the magistrate to get a more balanced picture before setting the formal criminal process in motion against someone.
It's a significant shift towards preemptive fairness. It allows the magistrate to potentially weed out baseless complaints much earlier, saving judicial time and protecting individuals from the burden and reputational damage of facing even the initial stages of a meritless criminal case. It strengthens the magistrate's role as a gatekeeper against abuse of the legal process.
Are there any exceptions to this new opportunity to be heard rule?
The proviso itself doesn't list exceptions, but the initial examination on oath part of Section 223 still has exceptions, like when the complaint is by a public servant or a court. But the opportunity for the accused to be heard before cognizance seems intended as a general rule for private complaints.
And Section 223 also has specific protections if the complaint is against a public servant.
Yes, it does. Subsection 2 adds extra layers of scrutiny if a private complaint is filed against a public servant concerning acts done in their official capacity. Before taking cognizance, the magistrate must not only give the public servant an opportunity to make assertions about the facts, but also needs to receive a report containing facts and circumstances from the officer superior to such public servant.
So internal check from the department as well.
Essentially, yes. It's a double safeguard designed to prevent harassment of officials through frivolous complaints related to their duties, ensuring that allegations of misconduct are properly vetted before a criminal case is formally initiated against them.
This whole section feels like a major rebalancing. What happens if, even after this process, the magistrate realizes they aren't the right court? Section 224. Procedure by magistrate not competent to take cognizance of case.
This mirrors Section 215 we discussed earlier, but specifically addresses the scenario after receiving a private complaint. If the magistrate, upon receiving the complaint, perhaps even after the initial examination, finds they are not competent to take cognizance of the offense, wrong jurisdiction, lack of power, etc., they must guide the complainant correctly.
How?
If it's a written complaint, they return it for presentation to the proper court with an endorsement explaining why. If the complaint was made orally, they simply direct the complainant to the proper court. Again, it ensures valid complaints aren't lost due to initial filing errors.
What if the magistrate is competent, has done the initial examination, maybe even heard the accused under the new proviso, but still has lingering doubts? They aren't sure if there's enough to proceed yet.
That's where Section 225, power to postpone issue of process, comes into play. This gives the magistrate crucial discretion after taking cognizance based on a complaint, but before issuing that summons or warrant.
They can pause the process.
Yes. If the magistrate thinks fit, they can postpone the issue of process to the accused. And during this postponement, they can do one of two things to get more clarity. Either inquire into the case himself, perhaps by examining more witnesses, calling for documents, or even conducting a local inspection, or direct an investigation for the purpose of deciding whether or not there's sufficient ground for proceeding.
Direct an investigation by the police.
Could be the police, or potentially another person the magistrate deems fit. This power to order an investigation at the pre-summoning stage for a private complaint is a significant tool for fact verification. However, there's an important limitation. The magistrate generally cannot order such an investigation if the offense alleged in the complaint appears to be one that is triable exclusively by the Court of Session or the High Court.
Why that limitation for serious offenses?
For very serious offenses like murder, the standard procedure is investigation via an FIR lodged with the police under Section 173. The law wants to avoid parallel, potentially conflicting investigations directed by a magistrate for crimes that ultimately require a full police investigation and trial in the Sessions Court anyway. So this power under Section 225 is mainly for verifying facts in less serious complaint cases.
So for a private complaint about, say, minor cheating, the magistrate might postpone summons and ask the local police to verify certain documents mentioned in the complaint before deciding whether to proceed against the accused.
Exactly. It's another layer of judicial filtering, allowing the magistrate to satisfy themselves about the substance of the allegations before formally summoning the accused, thereby preventing harassment through baseless claims.
And if, after all this scrutiny, the initial examination, Sec. 223, maybe hearing the accused, maybe a postponed inquiry or investigation, Sec. 225, the magistrate concludes the complaint just doesn't hold water.
Then Section 226. Dismissal of complaint becomes operative. This section mandates the outcome. If, after considering the initial statements on oath and the result of any inquiry or investigation conducted, the magistrate is of the opinion that there is no sufficient ground for proceeding, then they shall dismiss the complaint.
Mandatory dismissal.
Yes, if they reach that conclusion. And crucially, they shall briefly record his reasons for so doing. This ensures transparency and allows the complainant to understand why the case isn't proceeding and potentially challenge the dismissal if they believe it's erroneous.
So sections 223, 225, and 226 together form a comprehensive mechanism for scrutinizing private complaints before the accused is formally drawn into the proceedings.
Absolutely. It's a robust sequence designed to filter out weak, frivolous, or malicious complaints, protecting individuals from unnecessary prosecution while ensuring genuine grievances can proceed. The new proviso in 223 significantly strengthens this filtering process right at the outset.
Okay, assuming the complaint survives all this scrutiny, and the magistrate is satisfied there are sufficient grounds, it's finally time to formally bring the accused into the picture. Section 227, issue of process.
Correct. Section 227 details the formal act of issuing the summons or warrant, which officially commences the adversarial proceedings against the accused. This happens only when the magistrate forms the opinion there is sufficient ground for proceeding. Note that phrase sufficient ground. It implies a higher level of satisfaction than merely taking cognizance. The magistrate must be convinced there's enough substance to justify putting the accused on trial.
And how is the process issued?
As we touched upon in Section 217, if it's a summons case, less serious, the magistrate shall issue summons. If it's a warrant case, more serious, they may issue a warrant, or if he thinks fit, a summons retaining discretion. And here's that key modernization again. The proviso explicitly states, provided that summons or warrants may also be issued through electronic means.
Email summons, digital warrants. That's a big step towards efficiency.
It certainly is, acknowledging digital reality. But Section 227 also lays down crucial prerequisites for fairness before that electronic or physical process can be issued.
What are those prerequisites?
Two vital ones for transparency and defense rights. Subsection 2 states, no summons or warrant shall be issued until a list of the prosecution witnesses has been filed. The accused must know, from the moment process is issued, who the prosecution intends to call to testify against them.
Essential for preparing a defense.
Absolutely. And subsection 3 adds that for cases initiated on a written complaint, every summons or warrant shall be accompanied by a copy of such complaint. So the accused immediately receives the formal document outlining the specific allegations. There's also an administrative requirement in subsection 4 about paying process fees, non-payment of which could lead to dismissal, ensuring the process isn't abused.
So issuing process isn't just a formality. It requires the magistrate's satisfaction on merits, providing the witness list, and giving the accused the complaint details.
Exactly. It's a carefully regulated step, ensuring fairness from the moment the accused is formally brought into the proceedings. And as we mentioned, the Supreme Court is already emphasizing the magistrate's duty to be vigilant against abuse of process even at this stage, reinforcing the importance of careful scrutiny before issuing summons under BNSS 227.
Okay, the accused has received the summons or warrant. What happens next in terms of ensuring fair information and managing trial flow? What information must they be given? Section 228. Supply of copy of police report and other documents to the accused.
This section is absolutely fundamental to the right to a fair trial. It applies specifically to cases initiated on a police report where the magistrate has taken cognizance. It imposes a mandatory duty on the magistrate. They shall, without delay, furnish to the accused, free of cost, copies of all the essential documents the prosecution relies upon.
All essential documents.
Yeah.
What does that typically include?
It's quite comprehensive. It includes the police report itself, the charge sheet filed under Section 193, the first information report, FIR, recorded under Section 173, the recorded statements of all persons whom the prosecution proposes to examine as witnesses. These are the statements taken by police during investigation, recorded under Section 183. Any confessions or statements made by the accused that were recorded by a magistrate during the investigation under Section 183. Any other document or relevant extract which was forwarded to the magistrate with the police report, like seizure memos, expert reports, etc., under Section 193.
So basically the entire prosecution case file.
Pretty much everything the prosecution intends to use. And again, reflecting modernization, the section explicitly states the supply may also be made through electronic means.
Providing all this electronically must speed things up considerably. Why is this mandatory supply of documents so crucial?
It's the cornerstone of preparing a defense. How can you defend yourself if you don't know the evidence against you? This section ensures the accused knows the entire case they have to meet. It prevents trial by ambush, where the prosecution suddenly springs undisclosed evidence. It allows the accused and their lawyer to study the evidence, identify inconsistencies, plan cross-examination, and formulate their own defense strategy effectively. Non-compliance is a serious procedural flaw.
Is there any information that can be withheld?
There is a proviso allowing the magistrate, if they feel a document is voluminous, to let the accused or their lawyer inspect it personally instead of providing a copy. More significantly, another proviso allows the magistrate, after hearing arguments from both prosecution and defense and recording reasons, to direct that certain parts of a witness statement, perhaps revealing sensitive informant details or matters of state security, not be supplied if it's not relevant or disclosure isn't in the public interest. But this is an exception requiring judicial application of mind.
Okay, so the accused gets the documents. What happens next in cases that are destined for the Sessions Court because they're serious offenses, specifically those starting from a police report? Section 229. Procedure in cases instituted on a police report, triable by Sessions.
Section 229 lays out the magistrate's duty in this specific scenario. A case instituted on a police report where the offense alleged is triable exclusively by the Court of Session. Here, the magistrate has two mandatory sequential duties. First, they shall, without delay, comply with the provisions of Section 228, meaning they must ensure the accused receives all those documents we just discussed.
Document supply first, then what?
Second, after complying with the document supply requirement, the magistrate shall commit the case to the Court of Session. This committal is the formal act of transferring the case file and jurisdiction up to the higher court for trial. The magistrate here primarily ensures procedural fairness, document supply, before passing the case upwards.
So for a murder charge sheet, magistrate ensures accused, gets FIR, witness statements, etc., then formally commits the case to the Sessions Court.
Correct. That's the required flow under Section 229.
What if the serious Sessions triable case didn't start with the police report, but with a private complaint? Section 230. Procedure in cases instituted otherwise than on police report, triable by Sessions.
Section 230 provides the parallel pathway for these situations. If a case is instituted otherwise than on a police report, meaning typically a private complaint, and the offense alleged appears to be triable exclusively by the Court of Session, then the magistrate, after following the necessary preliminary procedures for complaints like examination, document supply, shall commit the case to the Court of Session.
So whether it starts with police or a private complaint, if it's a serious offense meant for the Sessions Court, the magistrate's job includes ensuring preliminaries are done and then formally committing it upwards.
Exactly. It ensures all serious cases, regardless of their origin, end up before the appropriate higher court for trial, but only after initial procedural steps and checks are completed by the magistrate.
Okay, now let's look at some dynamic powers during inquiry and trial. What happens if, during the course of a trial or inquiry, evidence suddenly points towards someone else being involved who wasn't initially charged? Can they be added midway? Section 231. Power to proceed against other persons appearing to be guilty of offense.
Yes, this is a crucial power vested in the court itself, Section 231, analogous to the well-known Section 319 of the old CRPC. It allows the court, in the course of any inquiry into or trial of an offense, if it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, then the court may proceed against such person.
Appears from the evidence, so it can't just be a suspicion.
No, it has to be based on actual evidence presented during the inquiry or trial testimony documents, etc. It requires more than mere suspicion. The standard, as established by the Supreme Court under the old section and likely to continue, is quite high. The evidence must be such that it strongly indicates the person's involvement, potentially strong enough to lead to a conviction.
So, if the court is satisfied based on the evidence, they can add this new person. How?
The court can issue a summons, or, if necessary, a warrant for their arrest. If the person happens to be present in court already, maybe as a witness, the court can detain them right there. Once added, this new person is essentially treated as if they were accused from the beginning and tried along with the original accused in the same trial.
This sounds like a vital safety net to ensure everyone culpable is brought to justice, even if the initial investigation missed someone.
It is. It allows the court to rectify investigative shortcomings based on what emerges during the judicial process itself. It's a power exercised by the court, ensuring judicial discretion. But again, because it's a significant power bringing someone into a trial midstream, courts are expected to use it cautiously and only when the evidence strongly warrants it, as affirmed in the Hardeep Singh judgment.
Makes sense. What about the accused's own voice during the trial? We know they have a right to remain silent, but do they get a formal chance to explain the evidence presented against them? Section 232, Examination of the Accused.
Yes, absolutely. Section 232, similar to Section 313 CRPC, enshrines a fundamental principle of natural justice alterum partem, here the other side. It imposes a mandatory duty on the court in every inquiry or trial to enable the accused personally to explain any circumstances appearing in the evidence against him.
When does this happen?
The court may, at any stage, put such questions as it considers necessary, discretionary, but crucially, it shall, after the witnesses for the prosecution have been examined, and before the accused is called on for his defense, question him generally on the case. This post-prosecution evidence examination is mandatory.
And the accused answers these questions under oath.
No, and this is vital. No oath shall be administered for this examination. Furthermore, the accused shall not render himself liable to punishment by refusing to answer or by giving false answers. It's purely an opportunity for them to explain, not a forum for self-incrimination under threat of perjury.
So it protects their right against self-incrimination in the Constitution, while still giving them a chance to respond directly to the judge about the evidence.
Precisely. It's not meant for the prosecution to fill gaps in their case, but for the accused to offer their explanation for incriminating circumstances. The court must put specific adverse points to the accused. Their answers, while not sworn testimony, may be taken into consideration and put in evidence for or against him. It helps the court understand the defense's perspective and clarify ambiguities before the defense formally presents its own evidence. Failure by the court to question the accused on material incriminating points can be a serious trial defect.
And finally, does the court have the power to call new witnesses or recall existing ones if it feels something crucial is missing? Section 233, power to have a material witness or examined person present.
Yes, Section 233, like Section 311 CRPC, grants the court very wide discretionary power to ensure all necessary evidence comes on record for a just decision. Any court can, at any stage of any inquiry, trial, or other proceeding, do three things: summon any person as a witness, examine any person in attendance, even if not summoned, or recall and re-examine any person already examined.
What's the guiding principle for using this power?
The only constraint is that the court must believe the person's evidence appears to it to be essential to the just decision of the case. The primary object is the discovery of truth. It allows the court to take an active role, to step in if it feels the prosecution or defense has missed a crucial witness, or if testimony needs clarification, or if new facts emerge mid-trial.
So if during testimony it becomes clear there was another eyewitness the police didn't find, the judge could use this power to summon that person if their evidence seems essential.
Exactly. Or if a key witness gave confusing testimony, the judge could recall them for clarification. It's a plenary power aimed at ensuring justice isn't thwarted by procedural gaps or omissions. But like the power under Section 231, courts must exercise it judiciously, not to fill deliberate lacunae left by a party or engage in a fishing expedition, but genuinely to arrive at the truth necessary for a just outcome.
These foundational steps, defining jurisdiction, initiating judicial process, ensuring fair information, and these dynamic court powers all logically lead to the next critical phase in a criminal trial.
Indeed. They set the stage perfectly for Chapter 8, which deals with the charge.
The charge itself?
Yes, the formal accusation. Chapter 8 lays down the legal framework for framing that charge, the precise statement that tells the accused exactly what offense or offenses they're alleged to have committed. Getting the charge right is absolutely fundamental for a fair trial because it's the notice that allows the accused to know the case they must defend against. #tag outro.
And that brings us to the end of this particular deep dive. We've navigated through the critical opening stages of India's new criminal justice framework under the BNSS.
Yeah, from figuring out where a crime should even be heard,
All the way to how a court formally takes notice and starts proceedings. And we can't forget that really quite revolutionary new right for an accused person to potentially be heard before cognizance is even taken in private complaints. That's a standout change.
Definitely a major shift. You've seen how the BNSS attempts to modernize older laws, tackling cybercrime jurisdiction head-on, embracing electronic evidence and processes where possible, and importantly, building in significantly stronger safeguards against potentially frivolous complaints or inherent bias right at the starting gate.
It really feels like an attempt to strike that delicate balance, doesn't it? Between ensuring justice is swift and efficient, while also rigorously protecting individual rights.
That's the tightrope they're trying to walk.
And understanding these rules, these foundational steps, it isn't just for legal eagles. It's really about understanding the system that affects everyone. How justice is accessed, how fairness is supposedly built into the process from the beginning, how society tries to establish truth. These are the real nuts and bolts, maybe with some updated digitally aware parts now.
Well put.
What really stands out to you after walking through these initial chapters? For me, beyond that precognizance hearing, the sheer focus on electronic means feels like a very conscious push towards modernization.
I agree. The technological adaptation is key. But if we zoom out, the bigger picture is how these procedural refinements aim to put the entire judicial process on a more solid footing right from day one. By filtering cases more effectively, aiming for clearer jurisdiction, and enhancing due process early on.
The hope is to minimize delays and strengthen fairness down the line.
Exactly. Especially in our current age, where information moves instantly and crimes can be, well, anywhere and everywhere simultaneously, these initial steps are crucial for ensuring the system can even begin to cope.
So here's a final thought as India steps into this new legal era with the BNSS. Technology keeps evolving at breakneck speed. Crimes become more complex, more borderless. Are these new laws, particularly around jurisdiction and digital evidence, robust enough for what's coming next? Or is this just one step in a continuous process of adaptation the law will always have to undertake?
That's the perennial question, isn't it? The journey of justice is never static. It has to keep evolving.
Something for all of us to think about. Thank you so much for joining us on this deep dive into the BNSS's opening moves. If you have questions, thoughts, or want us to explore other aspects, do let us know.
We'll be here to unpack it. Thanks for listening.